Melissa, which of course was like Dawn.
Okay, we're ready.
No, I am not eating this other yes.
Better than nothing.
We're not eating dinner, we get home. No, that's that.
All right, thank you, Pete. Now that we have our technical difficulties taken care of. Good evening for everybody in the audience and those watching at home. Welcome to your November 26th Planning Commission meeting. We have on the agenda 3 items, but now we will go to item number 2. Is there anybody here who would like to have a public comment for an item that is not currently on the agenda? If you would like to come and talk to us about anything, please feel free. We'll just wait a second or two because sometimes people go, well, I'm not sure I want to go. I'll move my water so I don't spill it. Nobody here for item number 2?
All right.
Okay, so we'll move on. So as I stated previously, we have on the agenda tonight, we have 3 public hearings. And we have our wonderful staff here who's going to help us out on all of this. So the first project is NR 1808 and US 1802. Natural Resources Overlay District and Geologic Hazard Review for an existing patio. And I think that says related improvements at First Avenue between Jerome and Miller Streets in beautiful Kanema. So before we get to the crux of the issue, I want to go through the quasi-judicial land use hearing script, and if it's okay, hopefully I only have to read it once. If anybody here wants me to read it the second or the third hearing, please let us know, but I doubt that, so we'll just do it once. So as we stated before, we have public hearing number NR 1808, US 1803, and it's scheduled for this evening. A staff report has been prepared for this application and has been made available to the public 7 days prior to the first public hearing. The staff report identifies the approval criteria that applies to each of the applicant's proposals. Staff has analyzed that criteria, which is contained in the staff report. The quasi-judicial hearing procedure that the commission will follow is set out in state law and in the Oregon City Municipal Code. The hearing procedure, and this is where I get to do Vanna, is over there for your edification, and we will follow that procedure. Anyone wishing to speak should fill out a speaker's card and give it to the planning staff before the hearing. If you decide you still want to speak, please just come forward and you can fill one out before you leave. We will, the reason that we ask you to do that is that so that we can notify you of the final decision. For the public record, please begin all testimony by stating your name. Testimony and evidence should be directed towards the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, please identify and discuss that criteria and explain how and why you believe that criteria applies to the application under consideration. Any person may submit written material while the public record is open on each application. Any materials received by the city staff during the period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the city staff in order for that to become part of the public record. If a person intends for PowerPoint presentations, oversized poster boards, reports, pictures, or other exhibits used in their oral testimony to be placed in the public record, copies must be submitted to the city staff while the record is still open. If they are not given to staff, they will not be included as part of the record, and then we cannot consider them. Any person wishing to request a continuance to present additional evidence and testimony or to keep the record open to respond to new evidence must make that request before the public testimony portion of the hearing is closed. If the Planning Commission makes a decision with which you disagree, any issue you may wish to appeal must be raised for consideration of the City Commission or the Land Use Board of Appeals or both. Without raising that issue on the record with sufficient specificity and accompanied by statements or evidence that the city and all parties can respond to, the issue will not be deemed appealable to the Land Use Board of Appeals. In addition, the failure of an applicant to raise constitutional or other issues related to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. We will now open the hearing for that particular file. I've already said it twice, but in our 1808 and US 1803. The commission, dear commissioners, does anybody have any ex parte contacts, conflicts of interest, bias, or any other statements to declare? And at the same time, would you please indicate whether or not you have visited the site? And I'll start with Bob.
No, I haven't visited the site, and no ex parte contact.
Okay.
I have not visited the site, but I examined the aerial photos.
The same, and I just met the Palmas tonight when we walked in the room, so it's my first contact with them.
I have not visited the site. I read the staff report and viewed the video from the Natural Resource Committee here 7, 8 days ago, 10 days ago.
Okay.
No, no, and no.
Okay. And I did visit the site and trespassed on railroad property to go down there and look at it. I did also review the other items that were mentioned by other commissioners. So does anyone in the audience wish to question us about any of these disclosures? If so, just raise your hand and ask us. Okay. Again, I just want to repeat, since we have a lot of new people here, that we will be looking for your testimony based on the applicable criteria. And please stick to that. Just for your information, we've got about 15 minutes for the applicant. Anybody here from the Neighborhood Association has some additional time, 3 minutes for individuals and 5 minutes for the applicant's rebuttal. And I will ask, do you have everything set up? Of course, because it's all perfect. Thank you. Yes, so we will be using the little buttons there. So if you, I can't see if that's in the way, so sorry. So if you see that starting to blink, please try to wrap it up. There are a number of people here tonight who want to speak, but we want to hear what you have to say. If you need a little extra time, just wave your hand, let me know. We will do our best to accommodate you. All right, so we are going to have a staff report from Christina.
Thank you, Chairperson McGriff. My name is Christina Robertson Gardner, and I'll be making the presentation this evening. Kelly Reed, the planner involved in the staff report, is unable to be here tonight. So I've read the staff report. I'm ready to make the presentation and be able to answer questions from both anybody in the audience as well as the Planning Commission. So this is NR 1808 and US 1802. These are both two natural resource and a US a geologic hazard overlay review for patio and access stairs in Kenema. Just really briefly, the project description. The applicant had river access through an easement not on their property to locate a dock. The boat access stairs and patio were constructed starting in 2013, and the applicant wishes to retain those existing improvements. The easement contains the permitted dock and the easement improvements, including a concrete block stairway, which I'll show you in a future picture, a low concrete retaining wall, a rock retaining wall, a graded kind of fine gravel patio, and a fire pit, along with some additional square foot of concrete patio. Additional site work included some grading, removal of existing vegetation, and some new landscaping. There are a lot of code criteria this evening. A lot of what I'll be speaking about is the Natural Resource Overlay District, as well as the Flood Management Overlay, though I am available to answer questions for the other chapters. I know Commissioner Espy did ask a question about the Willamette Greenway. We do have findings in here, and I'm able to answer those questions as well.
Yeah, I found the findings.
Oh, good. So interesting part about this project is the development is below top of bank on the Willamette River, and the site is small and is very steep and rocky. The on-land improvements trigger certain permitting requirements, and that's our Natural Resource Overlay District, which has a buffer from the waterway, as well as our geologic hazards. The dock itself was a Division of State Lands permit, which does not have city permitting. R6 single family use allows docks. So the dock itself was permitted through the state. The improvements on the shoreline is what we're talking about today, not the dock. And so to remedy the project impacts and to ensure the code is met, the owners applied for a land use approval for their pre-existing improvements. And our goal tonight is to provide staff's recommendation of which conditions are needed in order to provide an approval of the project and still meet our code. So some general overview of the area. The dock is in the circle area. The Kenema Club has a number of residential docks on different easements in one tax lot. And the property owner is located at 510, pretty much just across from the dock. They have easement access along the Kenema Club property, which is outlined in yellow. So their easement area is a piece of the Kenema Club tax lot where their dock and their improvements are done.
Would you say that again?
Sure. So the property owner is the Kenema Club, which owns the tax lot identified in yellow. There are a number of single-family residential docks. The Kenema Club is made up of different easements on top of that tax lot, and the applicant tonight, they have an easement in the Kenema Club tax lot for their dock and their area of improvements. So while the Popmas are the applicant, the property owner is the Kenema Club.
So who is the Kenema Club?
It is
a club of people?
It's a club of people who own the docks on the in that tax lot. So at one time, it was owned by PGE. They went through a negotiation with the property owners down there. An entity was created that now owns the tax lot, and there are sub-easements within that tax lot.
So the whole yellow area,
The yellow is one tax lot, and it's
One
owned
tax
by
lot.
an entity called the Kenema Club.
and that's tax lot to Oregon City.
Correct, in Kenema. And the Popmas have an easement on the tax lot for their specific portion. This shows the aerial photo of the dock. I know the commission can't see it, but the area, and I'll show them more photos, but it's really the concrete pad area to the left. You see the dock walkway, the kind of area to the left and the area to the right we're talking about. And there's stairs that come up to meet the railroad. This shows existing condition. So you'll see the dock, the concrete patio, the gravel patio. There is a small concrete block wall as well as steps. This is an existing condition today showing the gravel patio and the fire pit and the concrete wall. The applicant has indicated that the larger boulders to your left were existing condition on the site, whereas they leveled out the gravel area and put in the wall the small retaining wall to your right. This shows a picture of the dock.
Can I ask, are you saying that level gravel was not there before? It was just a rocky outcropping right there?
According to the applicant, correct.
They improved it.
They improved it. But the large boulders you see to the left closer to the water, the applicant indicated that those were historically always there. So they did not bring those large boulders in.
Are there any pre-existing pictures?
I'll show you what we have.
And part of that question is I know we're determining this on the city, but are these kind of things approved by the club that you were referring to earlier? Could they allow everyone to improve their own areas?
Well, that's a separate, legal matter between easement owners and the Kenema Club. So in some sense, it's really not germane to what we're talking about this evening.
Our decision.
Because we're not here to enforce, a private property easement.
Okay,
At
thank
the
you.
end of the day, the Kenema Club is the property owners, and the Popmas are the applicants coming in for their application.
Okay.
Tom mentioned the applicants or the owners level that gravel spot out and put in a wall. Is that correct? I thought a prior owner.
Correct, a prior owner did. And so they bought the property and inherited this existing use that
That's
needs
what I
to be
was
permitted.
wondering.
I understand, apologies.
If the Kenema Club is a property owner, what's their responsibility in all this?
That's, again, what I was wondering.
Well, let's let her finish.
Yeah,
We can
if
figure
I
that
could
out.
hold off on that until we get to the end, but as a city, I'm giving you the short round answer, which is we've been given an application to review based on an existing dock that was not permitted, of existing gravel area and improvements that were not permitted. My job as staff is to look at what needs to be conditioned to allow it to be permitted. And then I'm looking at the Kenema Club as the property owner and the Popmas as the applicant.
Can I interject there the same thing? Why isn't the club the one defending this since they own the property?
The Popmas move forward to submit the application.
Okay, not the club. The club owns that
The
money.
club had to sign the land use application.
Okay, that's what I was just confused why they weren't
Yeah.
the ones here.
The club did sign the application and the Popmas signed the application. So they have both signed the application to submit as owners consenting to the proposal.
Okay, thank you.
This is showing the dock looking north, just at the edge of the concrete pad to your right. This is at the dock looking back at the property. This is at the north end of the property looking south, so you can see the gravel area. And the retaining wall is just to really the left of that small tree bush. This is a historic photo during flooding event, and I don't know the year. I can have the applicant let you know.
Oh, the last one.
Well, no, it would have been recent. It would have been in the last decade. I mean, because this was just put in, so.
96 is what I
In
suspect.
the last, not 96, there wasn't a dock there. Dock went in 2013.
So that's the fire pit there, underwater
Correct.
there? Okay.
Yeah. And I can look up when that photo was. It would be after 2013, because that's when it was put in. This is looking upstream, and this is a close-in of that retaining wall. The applicant has proposed various removals of non-native species and replanting. So I'm going to show you kind of just a little overview. So removal and replanting proposals. This is showing a vegetative planting schedule and identifying some existing plants that are going to remain. There's a little showing the other side. So the NROD, the Natural Resource Overlay, has a mitigation. If you cannot mitigate to the level of your impact, this is kind of what the crux of what the Planning Commission is looking at tonight. So they are proposing removal of non-native vegetation from the easement area. They proposed planting of appropriate native plants to enhance the resource. They have requested an adjustment to reduce the mitigation area and use existing native plants to count as mitigation. And according to our math, the applicant is short 232 square feet of mitigation area because they want to use just within their easement area. And right now, staff has not recommended any reduction in the mitigation area and not counting existing plants. So we believe that there are alternatives available, and we don't believe that the applicant has shown that no alternatives can be done that can also meet the requirements of mitigation. And so we have proposed options for them. One option is to add 232 square feet of area within the subject property, and that could be outside of their easement area, but on the Kenema Club property. Add 1,928 square feet of additional invasive plant removal in the Natural Resource Overlay District, and that number was created by taking twice the size of their impact and then subtracting the existing mitigation they're proposing. So when you do that, the resulting number is 1,928 square feet, and that would be for removal of invasive species along, anywhere along the Willamette River Greenway, anywhere along the Natural Resource Overlay District. The third is add 232 square feet of the area off-site of habitat improvements, and then provide enhanced mitigation within the easement area. So more plants, rare species, so enhance the quality of what's being planted in lieu of the quantity of what's being planted. So in our staff report, we have all four of those are options. They don't have to pick those. If you agree with this, the Planning Commission can approve that condition, which allows the applicant to kind of think about what makes the most sense for them. But right now, we are not recommending flat out removal of the required mitigation. They are also.
Can I ask what does
Wait,
it
wait,
mean,
wait.
off-site?
Can you hang on just a little?
She wants to know what
Before she
offsite-
moved from that screen, I wanted to understand what that meant, off-site.
Off-site means off-site of where they are doing their impact. So usually you want to put your mitigation right where your impact is if you can. But if you can't, then you could potentially improve the riparian area or that planting area along the Willamette near the site.
Okay, near the site.
Yeah, so you're off-site, you're not on where you actually are doing
Okay.
your development. So they are also in our flood overlay district. So they have 12 cubic yards of fill estimated, so not a lot of fill happened, but some fill happened. Staff is recommending a condition approval to show balanced cut and fill somewhere within the flood overlay district. Right now, we do not really have a waiver, I shouldn't say variance because they could keep the variance. We don't have a waiver process in our flood overlay district, even though it's really small and de minimis, we really don't have that waiver process. You need to show balanced cut and fill. So there are ways to do balanced cut and fill offsite. There are ways to, it's really a mathematical proposal. They work with our building official and our engineering division to show, just like a bathtub with balanced cut and fill, when you add more fill into the flood overlay, that bathtub is getting bigger. So you need to do a corresponding cut somewhere else so you're not getting a rise. Even if it is a teeny tiny de minimis rise, the way our code is really set up is we really do not recommend any variances to our flood overlay district. We also have, we are part of the FEMA, excuse me, and I had it on my other slide and I apologize. We're part of a FEMA program where we have a community rating system, and that provides us as a city a reduction in our flood insurance. We are currently at a 10% rating. We're a category 8 now. And I don't know definitively if multiple variances to our flood overlay district for cut and fill would continually erase our ability to have that reduced flood insurance. So it's unknown. So at this time, staff really doesn't recommend any reduction in that cut and fill requirement because of how our code is
I
written.
heard a very interesting story on a very similar issue with cut and fill in Louisiana. And the comment from the commentator was that it did affect their flood rate insurance.
So I don't definitively know, but right now we really don't have it set up in our system to have a waiver for these kind of de minimis, because 12 cubic yards is not a lot.
No,
But it is, it's not nothing, so,
cumulative.
yeah. Oh, sorry, so that is my, staff report. I'm available to ask questions. I know the applicant is here. They are also kind of looking through these conditions of approval, and they're going to be deciding tonight if they would like to ask for continuance to allow kind of continually to adjust these options. So I'll leave it up to the applicant to make that comment, but if that does happen and the applicant asks for continuance, the Planning Commission will continue it. We'll keep the record open, and we'll bring this back when they're ready to kind of definitively say we can accept these conditions. But right now, they still wanted to kind of digest them a little bit more. And so I know that they're looking at asking for that continuance tonight.
Can you go back to some of the photographs there? That
Sure. Which one are you looking for? Just tell me to stop when you say it.
Oh, okay. You're gonna have to go forward now, it looks like.
I thought, from what I could read while you're looking the landscape plan, but, it's so small, I couldn't read what the plant materials were, even though I kind of tried to explode it on my own computer. It got to a
going.
point where I couldn't even read it.
Keep going. Oh, stop.
Okay.
Nope, one more.
That one.
Yes, thank you.
Okay.
Okay, thanks.
Can you, for those watching on cable and who aren't familiar, can you tell us what cut and fill means?
Sure. I mean, when you cut, you take away soil and take away rocks from an area, you're providing extra storage, right, in a flood incidence. When you fill, you're adding more built area into a flood. And so therefore, when the water comes, they have to go somewhere else. So I always think of it as if you dug a big hole, the water would go in the hole. If you added a big mountain, the water's going to go around the mountain. And so how material is added or taken away in a flood over district does affect the neighbors around you.
Around you.
Because everybody that's in the flood overlay district, are assumed in a flood event that, once again, if my neighbor built the mountain next to him, I'm going to get more of the water. So if my neighbor built a big, hole, more of the water's going to go there and less on me.
So this doesn't sound like it's a major cut and fill?
No, it's not a major
it
cut,
wouldn't impact
but the way
everybody.
our code is written, we really don't differentiate between de minimis or little things and a big, a big cut or a big fill.
So think of it as, if everybody did a little bit, what the cumulative effect is, that's
Right.
why at least
Okay.
from the layperson's standpoint, the floodplain regulations are written the way they are because you don't want that to happen. So everything has to be balanced,
Okay.
is the way that works.
And my thought was when I saw this picture and the one with the fireplace, fire pit, is that every year because we know that, well, not this year, we haven't had any rain, but does it flood often because it's lower to the river, or is this 1996?
Well, it
After-
is, I'm sorry.
Sorry?
It is below ordinary high water line, so it will be
Flood every year.
inundated. I think the key thing is that extra material has been added into the flood overlay district. So regardless if it's below ordinary high water line or above it, it's still both areas are in the flood overlay district.
Okay, thank you.
So where is the railroad right-of-way vis-a-vis this?
It's probably really close to the top of that bank.
Okay, well, we're not,
I'd say it's
We're
over the edge of the bank.
we're still looking at the flooding one. So you had that
Well,
one.
it's still the same. It's about the top of the bank you see to your left is where the railroad is.
I know that's where it is, but they have a 50-foot right-of-way. So I'm curious as to whether or not from the rail line, go 25 feet out from the center of that rail line, and you're really close, if not in the middle of
So
their
the-
patio.
The Kenema Club is a private
Right.
tax lot. The railroad is a private tax
Right.
lot. And so the differentiation is the differentiation. And I can go back to, let me go back to the very beginning.
Yeah, the one where you had the yellow.
There we go.
So it looks like the property,
But the tax lot is irrelevant to the railroad right-of-way.
And once again, the railroad's ability to enforce their easements is the railroad's ability to enforce their
Well,
easements.
yeah.
But I'm just curious
Having to
as
cross back and forth there.
if it's the railroad's easement, would we have jurisdiction in it?
I am looking at our natural, it's so hard because this is one of those, like, there's all these different inputs. I think what we're looking at tonight is there's 2 city overlay districts, two big ones that really are being triggered here. The third one is a geologic hazard, which is not as
Right.
much.
But I think we'd want to see some buy-in, some degree of buy-in from the railroad company to,
As
if they have permission to encroach on the right-of-way.
I'm gonna, at some point, I'd like to have a conversation with our attorney just to see where our relationship is at, is enforcing a third-party easement. I don't know.
Well, I don't know if we're enforcing it. I just, I know in order to go look at it, I had to walk across the tracks, which, I generally know when the trains are coming every time during the day, and I made sure that I was not there when I knew the train was going to be coming, obviously, because I have no desire to be hit by a train. But yeah, that just makes me really nervous. And with our high fire danger we've had for the last 5 years, I noticed a number of devices that could set things on fire, which also freaked me out.
So if this is continued, I can research that, but I know as in our realm, it's somewhat important to make sure what our blinders are, is what we can and can't enforce. And if there are kind of parallel review, like the Army Corps review or Division of State Land
sure.
review, we're here to look at our portion of it.
Right,
Right, I just,
But I can
I've got
respond.
a question.
we know about the railroad.
Carrie, what kind of legal grounds are we on with this railroad right-of-way thing, for the record?
The only criterion regarding ownership is that an owner sign a land use application. And the owner is defined in our code as the legal record owner of the land. I think it would be up to you to interpret who an owner is. I think we have, I don't have any reason to believe that the folks signing the application are not the owners. As our
Well, that's
code
not
is.
my-
We didn't have any question about that.
That's not my question. My question is, does the railroad, do we have any jurisdiction in a railroad right-of-way that would,
Did we give notice to the railroad?
Yeah, they very seldom respond, in my experience, but
So your question is, we approve this development within the railroad's right-of-way? Would we have some liability for that?
Yeah,
I think the
yeah.
answer is no,
oh, okay.
because we don't have any liability for anybody we have an obligation to review and approve land use criteria, and that's it. And if there is a dispute in ownership underlying something that somebody doesn't have authority, that comes out in civil proceedings and not in land use proceedings.
Okay, well, that answers my question.
Can I ask another question?
please.
On the yellow right here, we see the dock, and going up the right, is that a kind of a soil or a sandy area that goes out there? Or are there any other docks all along up there to the right, or is that just a sandy area of the river? I should have gone down and looked at it, but I don't.
Oh, there are other docks on the Kenema Club property.
Down here, but I was looking to the right. Is that
Oh,
a sandy
to
outcrop?
the north? I'm not aware of any, but they're here this
I
evening.
didn't
if you
go
wanna
there,
ask.
so I wasn't quite sure if that impacts any water flow or anything. Okay.
Christina, how did this get here?
This was processed through code enforcement.
Say again, I didn't hear.
This was processed through a code enforcement.
Again?
Processed through a code enforcement?
Okay, all right.
Take it.
Code enforcement out of your office, or was
This,
there?
it was a multi-departmental.
It's all irrelevant.
It was a multi-departmental review.
Because this came through code enforcement, I would prefer not to talk a lot about the code
No,
enforcement, but
he just said, he just asked a general question, so no, we do not want to discuss the code enforcement because that is not part of this, but just wanted to know how it got here. All right, any more questions for staff? I mean, we have another opportunity when we close the public hearing. Just one last question, so when was the staff report made available to the applicants and the applicant's consultant?
prior to posting on the agenda.
Okay. All right.
As I understand it, these improvements were made without any permit from the city to authorize it.
That is correct. This is an after-the-fact review.
Okay.
All right. Rick, pleasure to see you. Come on up.
Wow, he still is around.
Good evening.
Good evening, Rick.
I'm here on this evening for the applicants. My address is 18680 Sunblaze Drive, Oregon City. Planning consultant. My clients live at 510 First Avenue, which is, I think, well, you can see those are actually,
510, right?
those are actually addresses on there, so it's 510 is 510.
Yeah.
And when they bought that property in 2014, they moved in like the middle of December of 2014. They were under the impression from the previous owner that the dock had been legally permitted and that the shore improvements were legally permitted. They have an easement right to use them. It was part of the purchase of the property. They were happy as can be about their new home and their access to the river, which they use for putting their kayaks in the water. About a year and a half went by, and then the Kenema Club got word of a enforcement action against the property because of the fact that the previous owner did not get approvals to install anything on the land. He was under the impression from a written note that docks were allowed without any approvals, and he went and did that, had no idea that he had to do, at least according to him, he had no idea he had to do anything more as far as getting approvals for putting the patios, stairs, and wall in on the property. sad fact is my clients are caught in the crossfire on this thing. They've already spent close to $30,000 preparing this application with all the engineering, geotechnical reports, my services, application fees. It goes on and on. They haven't even done anything yet trying to resolve this. They would like to be able to continue to use the property they thought they were buying. It's as simple as that. So they are the ones who initiated this application trying to resolve a problem not of their making. So that needs to be very clear right up front. They had nothing to do with this mess other than buying the land and acting in good faith.
Just a quick clarification. Staff just said that that area is in yellow, so how could they buy it? It's an
They
easement.
bought the lot, tax lot or address at 510.
Right.
It has, as part of its deed, easement rights
Easement.
to the
Okay.
use of that
Okay, sorry,
62
I
feet of
misunderstood, 'cause
frontage.
You said they bought the property that they want to use, and I'm going, wait a minute, I thought
No.
this was an easement only, so they don't actually own it.
That is, they do not own the riverfront.
Right,
The Kenema
okay.
Club owns the property. They have easement rights to
Okay.
a 62-foot linear feet of frontage, basically.
That's just for the people at
between
home.
there and the railroad.
Right.
I had thought with my discussions with Kelly that we were getting to where we might be able to get some adjustment on some of these conditions of approval, but in further discussions today with Christina, I understand a little more clearly her concerns regarding granting any variance to the flood issue of cut and fill. We don't agree with that. We think that a variance can be granted. The amount of rise, if there is any, would be on the order of a 1/16 of an inch across the flow there. We're out of the floodway. We're in the flood fringe. Leonard Rydell, the project engineer, tells me tonight that it's his opinion that because we're so close to the falls, the effect of that is that it speeds up the flow over the falls. So that in fact, there's absolutely no impact on the height of the flood. So any impact, if there is any from this, it's an area about 13 feet by 13 feet by 2 feet high that we're talking about, the amount of fill. And Christina tonight said, that can be handled off-site. Well, where? That's the big problem. If we agree to this condition of approval, we've got a problem to know whose property we go dig a hole on. To correct one other point, she stated tonight that this is in the ordinary, below the ordinary high water. That's not correct. Ordinary high water is about, depending on which data you use, 58 to 61 feet. Elevation of the patio is about 4 or 5 feet higher than that, but it is in an area that is frequently flooded every few years. And the 100-year floodplain actually crosses clear up to my client's property on the other side of First Avenue. So we've got that concern that we really can't agree to a condition of approval we may not be able to get. We've got another one that requires the recording of a restrictive covenant or an easement on the property to guarantee that the improvements are done and the city has rights to do certain things. We can't record anything on property we don't own, so I can't, my clients can't agree to that. We have to get the Kenema Club to agree to do that, and so far we don't have an indication that they will cooperate. They may, but we don't know. And then there's the issue of the off-site. Well, there's a whole issue of mitigation to begin with. This thing was primarily a blackberry patch. It's a railroad embankment that was filled with lots of rock all the way down to the river. And any dirt that's there is just sediment that's come in from the flood. You can't dig a shovel into it. You can't, and to put anything in there you could plant something significant into, you'd have to bring in more fill material, which guess what? That means you got to excavate somewhere else. So it's a big problem. And not only that, but then how do you guarantee the survival of it? Because you have the issue of how do you get water to it, and on a regular basis. You got to carry.
River, that's pretty simple.
Well, yeah, maybe. I don't know. You got water rights there, Commissioner. Maybe practically you may be able to put a pump in there and spray it on there until somebody reports to the Water Rights Commissioners. I don't know whether we've got any right to do that. So there are a lot of problems with this thing, and my clients would just like to get their life back in order and stop hemorrhaging money on this thing. We think that the city shouldn't be quite maybe so zealous on this because of A, the minimal amount of impact, B, the fact they had nothing to do with it, even though I realize the problem runs on the land, but C, who else is going to fix it if not them? You know, that's the big problem. So based on that, I believe we're going to have to ask for a continuance to December 10th meeting. I've asked Christina if we can have a meeting. She said there may be property the city has on one of its park sites that could be used for NROD mitigation. There may be property adjacent to it or nearby that could be used. There may be a site somewhere we can use for fill compensation. There may be a lot of things, but I don't know any of them at this point. So we'd ask for a continuance to December 10th. If you'd like to go ahead and take additional testimony, then we can respond to that. But I would like to hold time to give you more information once I know those facts.
Okay.
Thank you.
You know what they say, caveat emptor,
I have an area in Park Place I can fill in behind my house.
buyer beware. Brent and Cindy, Carolyn, why don't you both come up same time? If please. We can't force you, but please.
Howdy. I'm Brant Potma and Carolyn Potma. You know, this whole thing has been so incredibly, intensely frustrating that every time, I mean, it's been going on for 2.5 years, intensely for the last 6 months, getting engineers report, stepping forward to try to get a solution to this has really been the only kind of movement we've made on this in the last 2.5 years. I mean, the reason why I think one of you asked the question as to why, kind of in an indirect way, why the applicants are the easement owners instead of the property owners or the builder. The reason for that is for the last 2 years, nothing happened. It was either postponed, nothing effective was accomplished through the Kenema Club or the builder. Neither one of them wanted to do anything. And so basically, I mean, anything substantial, meaning like going through the pre-application process is what the city wanted from the very beginning, from the very get-go. So Carolyn and I just said, let's see what we can do. And, you know, see what we can do with our immediate easement area and see if we can get something that we can work this mess out. Because it's been endless. And it continues to be endless. It seems like it's going to continue to be endless the way it's been going. Anyway, so we stepped forward, went through the process, got the engineer's reports, and then we, got the staff report and trying to work something out with the planning department. We seem to think that we were in a fairly better place, but tonight, just before we came here, we found out we had to take a couple steps back, and it's kind of the way the whole process has been going for the last 2.5 years. Every time we think we have something, it turns out that we don't. And it always seems to get worse. So I don't know what to tell you people, other than we really don't know where to turn. I mean, we've given it our best shot at this point. And just, I guess,
Anything you want to talk about with regard to the criteria or how this, so we kind of have to base our decision on, even though we've requested, continues has been requested.
About the criteria, about the things that Rick basically
We're going
mentioned.
to make our case in chief at the continued hearing, so.
Just say, Just say your name again real quick.
Rick Givens.
Okay,
We'll
thank
make
you.
our main
Okay.
case at the next hearing.
Okay.
Thank you.
So, yeah, I
Alright.
guess no, the answer to that would be, we'll just be
Do you have
quiet
anything-
on that, I
Do you have anything
suppose.
to add, Carolyn?
Carolyn Potma, just as my husband said, we've really done our best. We've really tried. We have deep respect for the river. We love living by the river. We would like to do right by the river, take care of the bank. But we just ask that we not have onerous things that we need to do on other places and more expense that really ultimately doesn't help the river. Thank you. Thank you for your time.
Thank you. Any questions?
No.
Okay. Ken? Howdy. For the audience, this is a small town. We know everybody.
Basinger, Oregon City. I live next door to the Popmans. I am the registered agent for Kenema Club and the president of Kenema Club. So I can answer all of your questions that you had about that, but first I want to say something about the railroad easement. Correct what you said. It's not 50 feet wide, it's 15 feet from center line, so 30 feet total width. Secondly, the railroad owns no property in Kenema. The railroad right-of-way sits entirely on the dedicated easement for First Avenue, or dedicated right-of-way for First Avenue. So does that make that part clear? I hope.
Well, my only concern was whether or not we had enforceable ability, and clearly we do, so it's
Okay.
not relevant anymore.
Okay, so if you'll go to the next picture.
Sure.
I sent you a memo, which I am speaking only for myself, not for Kenema Club or anyone else in that memo. But I'm talking about the nature of the land itself. In this picture, you can see the natural beach as the shaded area underwater extending clear out to the edge of the Bahamas dock. That was the natural sand beach of the river before the construction of the PGE dam. That is all now permanently underwater. The next thing you see moving uphill toward the railroad is a band of dry rock. Everything from there clear over to the paved First Avenue is fill. It's heavy rock fill brought in when they blasted away the Oregon City Bluff to put in Highway 99 and the railroad rights of way. All of the rock from there was dumped along the Kenema waterfront to provide a barrier, I guess, from future flooding after the 1861 flood. A man named Holiday, no relation, owned that property in the 1860s and intended to put in a portage rail line to compete with the idea of a future Willamette Falls locks. And in bringing in constructing that line, he brought in all of the additional fill on top of what was already there. So there's not a square foot of natural land on the Kenema Club property between Miller Street and Paquette Street. Not a square foot. Every bit of it is fill. And that's why in my memo I questioned first the appropriateness of a natural resource overlay on a piece of property that is entirely not natural. And then secondly, to ask for a removal of the mitigation for planting more plants that are just going to be killed by the next high water event. And the question was, how often does that happen? I would say the high water that you saw in there has happened about 4 times in the last 20 years. So about every 5 years on average would it get that deep. The 96 flood was about 6 feet above the level that you see there in that picture. Any plants that they put in for mitigation purposes, no matter what they are, if they're between the concrete slab and the river, they're going to drown because they will get flooded. If they're between the concrete slab and the railroad, they're going to get sprayed by herbicide from Union Pacific. So what's the point? What's the point of requiring them to do that? So I'll answer any questions.
So why didn't the Kenema Club file this application?
The Kenema Club was formed purely as an instrument to purchase property from Portland General Electric. To raise the money to do that, we sold exclusive use of pertinent easements to the adjacent property owners. In other words, we own the easement to the left of that one. Popmas own that one. Other people own each property owner along there who wanted to participate in that purchased an exclusive use easement. All of the property has been sold off in easements so that Kenema Club retains no property rights. Kenema Club can't walk on the property, can't drive a stake in the ground on the property, or can't construct anything on the property because we signed away all of those rights to the easement holders.
But you're still the owner of record.
Correct.
So you're still the
We have the right to pay the property taxes, is what it comes down to.
And you're still responsible for things that happen on that property.
True.
So why didn't you file the paperwork?
Because we can't.
I'm not sure why you can't. If you're the owner, you're responsible for it.
We have no right to build anything on any portion. Kenema Club has no right to build anything. We signed all those rights away.
But you're still responsible if somebody builds something illegal. Just because I sign the rights away to grow something in my backyard doesn't mean that I'm not going to get hung when the feds roll in and confiscate all the pot plants. I can't say, oops, I didn't know what they were doing.
Allow me to say we've spent $12,500 on an attorney, and at this point, I'm going to say no more on that topic.
Fair enough.
I got a question. Carrie, what kind of legal grounds are we on here with this point?
I don't think it makes any difference. We have an application that was signed by both the easement holder and the underlying property owner, indicating consent for this application.
So
We have to review it pursuant to the criteria. That's where we are.
So because they signed the application, they are making the application along with the property owner, right?
Correct.
Okay.
And whether they're on the hook to do mitigation is a question of real property law between the two of them and has nothing to do with us. We have staff has recommended conditions of approval that require certain things. Who does them? That's a question for them to sort out.
Okay.
I've got a question for Carrie as well.
Are we done with Ken?
I am. Yep.
Okay, Ken, thank you so much.
Thank you all.
So I'm looking at,
We might call you back.
I'm looking at the application.
We do have one more person to testify.
Okay, but I just
Yeah,
got one.
go ahead, go for it. I just wanted to let you know.
Okay. I'm looking at these applications that we have before us, and they all involve the natural resources. I don't know if we really have any authority at this point to be able to vary any of the requirements that are required for mitigation
We
and
don't.
any of that. I think they'd have to apply for an additional variance.
Which there is no procedure in there to apply for that.
I don't know.
That's what Christina just said.
You're talking as it relates, they
said.
did apply to do a different type of mitigation, which you do have the authority to review under natural resources. They did not apply for a variance to not balance the cut and
I
fill.
guess the bottom line is how much wiggle room do we actually have to allow one type of plant material over another and all that kind of stuff without even discussing.
Under the alternative planting plans for the mitigation, you do have some authority as it relates just to the NROD.
Right.
But the staff recommendation is that there is quite a lot of land in the tax lot. There's land around the area along the Willamette River and thereabouts. So that's why we came up with the 4 options, so that they have a little bit of flexibility and that they could pursue some of the options, either plant less at a higher quality, plant somewhere else, that kind of thing.
Well, those kind of plants will probably do much better in that hydrologic regime and soil regime anyway. I wouldn't think that other plants, but that's a whole other conversation.
There's a condition of approval to have a wetland scientist sign off on the planting plans as well. So that we'll get that scientific perspective.
Can I ask a question? So this came through code enforcement to us. So are they the only property that's being questioned, or are we going to see the rest of them come through code enforcement? Has somebody made it so that that whole area is in question? Can we know that?
This is the only, this is what is before you.
Okay, so there could be others, we just don't know. We're not allowed to decide that.
Well, that's not the question that you're being asked.
Asked tonight.
Okay,
The question is, does this application
Right.
satisfy the NROD, the floodplain, the Willamette Greenway criteria?
okay.
That's it.
I was just wondering if it was the beginning of a lot. A lot. Okay.
I'm gonna go ahead and call, oops, just a minute, lost the slip. Leonard, come on down. Do you want him to say anything? He filled out a slip. Maybe there's some questions that he can answer for those of us that are not in that field. Hi.
Thank you. I'm Leonard Raydell. I'm a civil engineer and a land surveyor and a water rights examiner. I would encourage you to be a little more realistic on the conditions. A wetland scientist, that's not a wetland there. That's a rocky field built by the railroad. We don't need to there. I would like to see we be able to count the existing native plants. They're already growing good. The Douglas spirea, which you see there, downstream of the gravel bank, they're well established, and it just seems punitive to not count existing native vegetation. So I think replanting the site is an acceptable option. It's just having climbed over that bank and you slip and slide down the rocks. It's not a natural resource site. There's virtually no topsoil there. You're gonna have to bring in dirt. It's gonna be hard to maintain. You're gonna have to carry water from the river.
Did you say acceptable or unacceptable? I couldn't hear what you said. Replanting. The plan.
Say a little more of the sentence again. It's a very steep.
I didn't want to interrupt you, so I.
No, it's a very steep bank. And actually, we don't know where their easement is. The easement starts from the ordinary high water line, and then it goes to the railroad right away. And there's a railroad map that there. The first railroad in Oregon City, I think, was 1848, which was a horse-drawn thing on tracks. And by the 1870s, the railroad had already reached Roseburg, so the railroad's been there a long time. Maybe you should give them a little bad time about dumping rock on the tracks too, because the floodplain goes across on the maps to the tracks to Water Street. So I would encourage just keep the requirements to landscaping only. It should also be noted, according to the deed, that if the Popmas don't pay dues for 6 months, they lose their easement rights and therefore their responsibility. So That's always one option for them. I'm kind of amazed that the person that built the dock has no responsibility in this at all for not getting a permit because
Well, the dock has a permit.
or excuse me, the guy, he built the dock and the patio. They said the patio, there was already a natural level spot in there. They just leveled it out. But it seemed like the person that did it's getting away scot-free and.
I don't know. They don't probably want to spend money on attorneys, but
Yeah.
But no attorney, but you recourse prior owner is a civil matter.
And railroads are very interesting. Actually, I did a seminar, but went at the Land Surveyors Convention, and it's like a $10,000 fine if you're caught crossing the tracks. So
if you're caught,
that's just be careful. Don't have one of the railroad police get you because they can arrest you and throw you in jail on the spot. So
invite them down for a barbecue and it'll be okay.
yeah, and part of that is they're trying to keep the trains are getting so quiet now that people can't hear them coming. So.
So you mentioned one plant material. What else do you consider to be native vegetation that's down there?
I'm not an expert on native plants.
Well, I mean, you whipped that one off like, woo, I said, okay.
Right, because I remember, because I do a lot of landscaping plans. My partner, Jackie, her memory is incredible. She walked the whole site. She knows all the native plants, what kind of area they need to grow. Her knowledge astounds me. And so she really laid out the plan. I just drew it, and since somebody needs to do a stamp, I put mine on there because I felt confident in supervising the work done by others. So
you did a great job.
I think she would do a wonderful job there. And any questions?
Nope.
Thank you very much.
I would only say that although there's a butterfly bush down there, they are now on the Oregon State University noxious weed list, so they should be removed wherever possible.
So,
Doug, come on up, please. Maybe you can help us out here. I don't know if all the commissioners were able to look at the tape from your meeting.
Doug Neely, resident of Oregon City. I'm not here as a spokesperson for the Natural Resource Committee, which I chair, but we did invite the applicant to address us. We had a considerable discussion, and I wanted to share some of the things that came out of the discussion. Number one is exactly what the previous gentleman has said. We believe the plantings in the mitigation effort, the chances of them surviving are probably really, really low. My suggestion is to actually have a person come down, a botanist, to look at what the native material is currently there. It's established itself, it grows there, and probably the plantings that should be made are things that you see that are native that in fact could grow. But it is very frustrating to go into an effort of restoring an area of plantings, investing a lot of money to put those plantings in, and then have them disappear. And that aspect of it doesn't make any sense. The area does get wet. I would argue it is a wetland, but it surely doesn't have some of the qualities that like a lot of the other wetlands do. There is a habitat there, and as I say, the best thing to look at is what native material is there and can it be used. A lot of the willow species, native willow species, for example, although I'm not sure you could stick the stakes into there, they form advantageous root systems directly off the stem, and they just push these stems in. They root, and if they can take a hold, they'll take hold. If they can't, they won't. But I think there are a lot less expensive methods of introducing these plants rather than going through a major effort of plantings that would just probably get destroyed.
Have you looked at staff's proposed mitigation plan?
We saw what we saw, but no, I don't know what the species recommendations were. But my understanding is you'll have a person that'll go through that and take a look at it. But I think the most important thing is find the species that are already there that have been successful and use that kind of material.
Well, hold on, I've got a question for you. So besides being on the Natural Resources Committee, you're also involved in the Watershed Council, I understand.
Yes, I chair the Greater Oregon City Watershed Council.
Is one of the things that a watershed's responsible for, is fish habitat or fish restorations?
First of all, we're not responsible for
Well, I know
anything.
that. I mean, when you say a watershed.
But we're not irresponsible.
Yeah, but when you call something a watershed,
Yes.
then things that keep the native animals as well as the native
Oh, yeah, the
plants is part of it.
watershed is the area that provides the water to the stream in question.
So would it be appropriate to consider the shade area provided by the dock and the access to the dock to be beneficial to the fish life?
It could,
Okay,
yeah. I mean, some of the species will look for shaded areas. They may go under there.
yeah. Okay, because it seems to me like that's some mitigation to the whole holistic area of the land.
Well, for example, we find that salmon oftentimes like to, if they have gravel under bridges, they actually like to spawn under those bridges.
Right. Yeah, I know that's been one of the big
But
things.
this will not be spawning habitat.
No.
Not for salmonids or lampreys at least.
Right, but it could be a shaded resting area,
Sure.
which
Yeah.
the whole rest of the river isn't shaded to a large extent,
Yes.
so, okay, thank you.
Rick, did you want to say anything else or
Just save it for the,
save it for later?
I believe I'll save it, thank you.
Thank you, okay.
Chairperson McGrief, just before the meeting is closed for this application this evening continued, I want to enter in the record the memo from the Basingers as exhibit number 1.
I thought it was only one Basinger.
Sorry, Basinger singular, excuse me.
Well, hang on. So, before we close it and make our vote, I just had a couple more questions for you, Christina. So, because this is along the river's edge, what is the jurisdiction of the Division of State Lands? If there is any. I'm questioning that there may not be, but I know they have jurisdiction over the dock and those sort of things with permits for those sorts of things.
Yeah.
But they may not have any jurisdiction.
they've just got the 1 foot mark, don't they?
So the city's jurisdiction is to regulate the vegetated corridor only, not the water itself. There is a condition of approval, though, related to a criteria in the Natural Resources Overlay District that states the applicant needs to tell us if they need any approval from DSL or Corps or anything like that, and then secure any approvals that they need. So that's the only tie-in, is that they
Right,
just need
that's-
to follow up with that.
Yeah, and I was just trying to find that condition.
I think it's 1. Off the top of my head.
Oh, yeah, so, yeah. I guess just as, yeah, I think that was my only other question, so we can,
Denise,
yes, sir.
does it matter that the gentleman who testified has been raising his hand up there?
I could clarify.
We can't talk from the audience, unfortunately.
Can he come up and clarify?
Did you close the record or?
No, I
No, she
haven't
hasn't
closed it.
yet.
I was just getting ready to make a statement and then,
I could clarify the Division of State Lands because I got
Please state your
yeah,
name.
you just have to say your name
Yes,
again,
oh,
sorry.
I'm sorry.
That's
I'm
okay.
Leonard Riddell again. I did some research, but basically the Division of State Lands has jurisdiction over the riverbed, and there's a federal statute and there's a state statute. And basically, it's to the ordinary high water line. It's generally defined by the vegetation line. In other words, anything that gets flooded out is part of the riverbed, and everything above that is not.
So on the picture behind us, the brown band underneath the dock walkway would be, just for the ordinary layperson, that would be state lands, but all the vegetation on up towards the railroad would be city lands.
Right.
Okay, I'm just, as a rough layman's.
Basically, it's determined by the
Right.
courts.
Yeah. Yeah, I knew it was the high beam water line and
if you
all
want,
that.
I
I
can
just wanted to
introduce
make
that
sure.
opinion from the Attorney General for Oregon in the record. Thank you.
Thank you.
Okay, well, I'm going to close the public hearing for now. And if there's any further discussion by the commission. I had just Go ahead, if you have a couple things, yeah.
No, I was just gonna say, the only thing I got left is the
Yeah, I'm not.
continuance, but you
Right.
had something to say. So.
No, it's not to say, just questioning. I think that there, I would have to say right now, and it's not for, it's not a decision, but I wouldn't support anything that was done off-site because I don't really see what the point of that is. I do like Doug's suggestion. It was something I had already written down because, like I said, I couldn't read all of what was on the landscape plan on my own personal computer because it was too small. But if there's a possibility of staff getting maybe even just a 8.5 by 11 or 11 by 14 shot of that, I could look at it. Because I had a question too about what species are already there, excluding the butterfly bush and anything else that's a noxious weed, because I definitely don't want to support people planting that stuff. And I hope that that gets taken out. But I think that we have, I think we generally have a situation where, we have a rock and we have a hard place. And we do have requirements and standards, and I think we have to look at that very carefully. I'm not saying that we're making any decision, but I think we need to look at it. But I think we have some questions about, what's already there. I'm certainly not a person that can identify plants, even if I have the book with me, but maybe I could with the book. So I just want to be sure that we take, everything we can into consideration. I'm not saying that our requirements are onerous or anything of that sort, because we have a reason for these requirements. And we just have to figure out how to make this work. I know that they're probably really mad at the people they bought this property from, and they probably should be. But you want to make a motion for continuance?
Yeah, I want to take Doug's comments to heart about making sure that there's a reasonable approach to a planning presentation.
Yeah. I support that.
I recommend that we continue PC 18-148, NR-1808, and US 18-02.
Second.
To a
December 10th?
December 10th.
Thanks.
And I second it.
Okay. So it's been moved and seconded, and,
Call the vote.
and we will in just a second. So we just want to be, clear that, so we are continuing this as requested to December the 10th, and this probably will be, I'd say, one of the first items on the agenda. And I know that staff will make, every effort to listen, but again, we don't have any way to vary anything. So we really can't do that according to the code.
And the public record
It will remain open. So any additional items could be submitted, and, we appreciate everybody coming in tonight and testifying, and we certainly are not in any way blaming anybody. This is typical land use application. We have to go by the criteria. So that's kind of where we are. So would you call the roll, starting with Mr. Mahoney?
Commissioner Mahoney? Before I cast my vote, I got a comment or two.
Please, sir.
This demonstrates to me if the applicant thinks he's frustrated. I guardedly say that this demonstrates to me somewhat standards gone amok. And I'm going to encourage the staff.
Please don't clap. We don't really allow that here, so no clapping or cheering from the
And
audience,
I didn't
please.
mean it for that.
Yeah, I know you did.
But I'm going to encourage the staff to make this as simple for the applicants as possible. I don't think that we adopt standards in this community to add on another $30,000 of expense to an applicant to meet our standards. And I think service to the public suggests to this commission that we take that under consideration. That's the extent of my comments. But I agree. My vote is for aye to continue this.
Can I say aye?
Aye.
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 Yep. My one comment is, as I said to Commissioner Maybe, if I had $1 for every time when I was working and planning for somebody that came in and said to me, they didn't know something, my heart goes out to you. You just have to check everything and check it and triple check it and quadruple check it. But And I vote aye for the continuance.
Like I didn't know a road was going.
Okay, motion carries. Hearing for this is continued to December 10th. Well, I'm just saying, wherever
We can, and I think Christina will. I have no problem with that. All right, so now the next exciting public hearing on our agenda is GLUA 1820, AN 1802, ZC 1801, and MP 1804. And before I open, I just have a quick question. Did we have was there a copy of, or an approximate drawing of the minor partition in the packet? Because there was a couple things that I just didn't see when I was scrolling through everything.
Yeah,
So
there was a full breakdown.
Okay, so we'll get there. All right. So is there anybody, I don't have any slips for this. So there's nobody here for that particular item?
I believe the applicant's representative is here, so if you want to fill out a comment card after you've spoken, we can do that.
No.
We still need
That's what I said, the first part of the public hearing. I said, please fill out a card.
So I'm going to give the presentation first and then.
Yeah, so, yeah, you can do that.
Before you start, Pete, let's go
Yes.
through the,
I'm getting there. Just hang on, I'm getting there. So if it's okay with you guys, I don't want to read that whole land use thing again if you're okay with that. But I will ask for any ex parte contacts for the commission or any site visits or anything else that may affect your ability to give a fair and equitable decision. So I'll start with Mr. Godden.
I'm fine.
Did you visit the site or do you have any ex parte contacts? Okay, so we know you're fine, that's good.
No, no, and no.
I drove by the site today, didn't get shut off the vehicle, just cruised through it to see where it was located primarily. No problems.
I did the same last week.
I took a drive-by and I have no ex parte contacts.
No visit to the site, no ex parte contact.
I did visit the site today, and I will say for the applicant, your land use sign that faces Maple Lane was falling down. So that needs to be visible so that when some person like me is driving by, I knew where it was, but just FYI, it had blown over. I did visit the site and made a cruise through the entire subdivision just to kind of look at it again, and made note of that and talked to the horse that was on sticking its head over the fence.
Did it talk back?
It was nodding and whinnying because it thought I had something for it to eat, and I did not. So
you have to whisper.
Yeah, there was no horse whispering going on there. All right, so Pete, is this yours?
Yes.
All right.
Thank you, Commissioners. Chair McGriff, this application is an annexation request for zone change and a 3-lot minor partition for a 0.76 acre property located at 14530 South Maple Lane Road. File numbers are listed here, and the applicant's requesting approval of a petition for annexation into the city. The site is within the urban growth boundary and has comprehensive plan designation of low-density residential. The zone change request consists of a request for R6 single-family residential zone, and the applicant is also proposing a minor partition with this application concurrently into 3 lots. There's a transportation analysis report from our consultant, John Replinger, and that analysis indicates that if the partition were to be approved, it would result in 2 new dwellings potentially, and they could produce 1 new additional morning peak hour trip and 2 new additional evening peak hour trips and 18 new weekday trips if 2 new homes were constructed in addition to the existing home. That analysis report also looks at the items that you see here with respect to intersection and driveway spacing, site distance, safety, consistency with the transportation system plan in terms of what street improvements are proposed,
and concurrency with the transportation planning rule. And as conditioned, as recommended by staff, that would include a requirement to provide a proportional share cost of the improvements to the Beaver Creek Road 213 intersection. And that's a condition of approval, and it's been calculated out to be roughly $200 for the trip that would go through there, based on the cost of that improvement in the transportation system plan. All utilities can be constructed to the property and not create off-site impacts to the system. This is an aerial photo of the site. It is adjacent to the city limit on 3 sides and Maple Lane Road to the north. The urban growth boundary is the purple line at the top of the screen there. So you can see that it's well within the urban growth boundary. And to the east, you have Clearwater Place, which is an Oregon City local street. There are existing sidewalks constructed on the applicant's side of the property on abutting Clearwater. No current sidewalk along Maple Lane Road. That would be a condition of the approval for the minor partition, along with dedication of additional right-of-way to accommodate the width for a collector level road such as Maple Lane. Yes.
Just to be clear what you're saying about the sidewalks.
Yeah.
On Clearwater Place, the sidewalk continues all along the length of their property.
Mm-hmm.
But there is sidewalks on Maple Lane. They just stop at the edge of his property line.
Right.
Okay.
Yeah, they stop here, so.
Yeah, I just want to make sure that they're clear about that.
And can I get a clarification? Can you explain the pink outline?
This one here?
It's the city limits.
That's the city limits
That's the
this
city
way,
limit.
not that way.
That's what he just said.
I thought so, but I wasn't quite.
Yeah, it
looking north or
extends
south.
across Maple Lane. So our typical requirement with an annexation is that the entirety of the right-of-way be part of the annexation. So when it's finalized, we require that the legal description that's sent to the state and Metro include all of that property as well.
Is Maple Lane still under county jurisdiction?
It is currently, yes, yeah.
We have no plans to take it over until it's improved, I presume.
Well, the way we work with the county on Maple Lane Road improvements is they are willing to accept our standards as long as they are in compliance or like theirs. So that's generally what's happened along Maple Lane here. But in terms of the long-term acceptance of that jurisdiction, that's something that we'll be working with the county on. This is an overview of the zoning. So you can see that the FU10 designation is what's on the property now. That's the future urban designation of 10 acres, Clackamas County. So it's a holding zone for properties within the urban growth boundary that they can't be subdivided into parcels less than 10 acres until their urban services are provided to them by the city. And then the subdivisions to the south are zoned R6, single family, which is the same designation that the applicants were requesting. And to the east of there, you'll see the medium density residential zone of R3.5, which is 3,500 square foot lot minimum. This is the cutaway or snapshot of the proposed minor partition plat. And you can see that the parcel 2 is the largest parcel proposed. It's approximately 14,152 square feet. That's where the existing home is. Based on the fact that that home is currently occupied and the applicant lives there, the owner lives there, is not proposing to remove that home, and its location on the site is set up in such a way that you cannot facilitate an additional partition out of that property at this time without making a change to the home or requesting some sort of variance to the R6 dimensional standards. Therefore, they're able only to facilitate a 3-lot partition. rather than having to do a 4-lot subdivision or greater. And based on what we are determining to be buildable area and the presence of the existing home.
If they remove the dwelling, they could do a serial partition, couldn't they?
If they did, I think, that would be subject to another minor partition process. And I think that parcel 2 is set up in such a way that through the use, potentially, of use of flag lots or, a straight line, if the house was to go away, that could facilitate an additional partition. And that would be reviewed against the same criteria that we're looking at this partition.
Pete, that, just to the left of parcel 3 there, is that a right-of-way down at the?
So tract A there.
Yeah, tract A, right.
Okay, let me look back here.
Is that public right-of-way?
At the aerial photo, just so you can.
It's a utility easement.
Yeah, there's an easement there intended to continue the alley there, coming off of White Horse Court, utility and potentially an alley in that situation if that parcel, let's see, what am I talking about? Yeah.
Okay, I got you. All right.
So,
all right.
You can see that's an alley. But it's not necessary in this situation to provide further alley access because it's got access onto Clearwater Place.
Okay.
Parcel 1 is right around 6,000 square feet, and parcel 3 is 10,347 square feet. So they're meeting the minimum lot depth and width and size requirements for the proposed R6 zone.
What is the side yard setback in the R6 zone?
Side yard setback in the R6 zone, I believe the minimum one is a 5 foot.
Does it look like it was 18 inches?
Yeah, it's really tight for the existing house, but I believe they're meeting the 5 foot minimum on that side.
Can they meet that by moving that line over just slightly?
Well, I think you're looking at, okay, so this,
I'm looking at the one at the
this one
staff
here.
report.
Okay, so we would consider this the rear yard, and that would be having to maintain. What you're seeing here is a proposed easement,
It's
not a set.
It's not that, we're talking about the corner of the actual building.
Oh, well, there's a number there, but is that 5 feet?
The
You're looking at
application,
the staff report on the,
it does include a 5-foot setback from the corner of the house to parcel 1, so it does meet that setback.
sorry, I don't have that up on my screen.
Okay. The 5 is so tiny that the topo line is going through it where it says two 12-inch or 12-foot spruces, I think. I said it gets very small.
Okay. Yeah, well, they are able to meet all the dimensional standards for the zone.
What about the driveway access onto Maple Lane?
So currently, there's a driveway on Maple Lane. The general focus for Maple Lane is to remove access there so that you can take access off the minor street because it helps with traffic flow as development occurs.
They drive they drive very fast on Maple Lane. I use that very occasionally to go the back way to my in-laws, and I pulled out onto Clearwater, and they were just. I wish I'd had a checkered flag.
Yeah.
Because I could have been waving them in.
Right. So now we're going to do about the speed limits on Maple Lane Road or under county
It would be
speed
safer if
posting.
that one was closed, to be honest with you.
Yeah, well, I believe that's the proposal.
I would not want to
And
pull
then
out from
this area here would provide the driveway, and they would have to relocate the current driveway to meet current spacing standards for
I'm on the
off of
partition
there.
one.
Sorry, so let me move on and show you
Okay.
that. This is the Google Street View of the site, and you can see the loop driveway and where it comes in now. Just going over what's proposed as far as changes that would occur with the annexation. Currently, the property is served by Clackamas County Sheriff's Department for emergency services, and upon annexation, the Oregon City Police Department served the property, so that would change. Territory will remain in the Oregon City School District, remain within the Clackamas Fire District number 1. And I believe we've actually not recommending that it remain in Clackamas River Water District. We've got comments from them saying that it should be disconnected. So the third bullet there regarding Clackamas River Water District is incorrect.
So it moved to South Fork.
South Fork, and it would become part of the South Fork Water District as well, as part of that. And then they're required to connect separately or annex separately to Tri-City Sewer District in order to make the connection to the sewer plant. Comments received were all from agencies. Clackamas County had no comments. Clackamas River Water, as I indicated, would coordinate the disconnection from their services during the construction plan review. The school district says that all public schools for this property have capacity to accommodate any students that would eventually reside at the address. And Tri-City Service District commented on the requirement to annex separately to the sewer district and provided the annexation packet link for that. The city's criteria for annexation are contained in the chapter 14 of our code, and there are a set of factors that the city needs to make a determination regarding a positive balance of these factors. So it's not as if all 7 of them have to be met, but in this situation, we always analyze all 7 factors, and they include adequacy of access, conformity with the comprehensive plan, adequacy of public facilities and services, compliance with the revised statutes pertaining to boundary changes for both state rules and Metro Code. So that's the Urban Growth Functional Plan, Metro Code 3.09. Applicant provided detailed narratives response for all of these requirements in their packet. Finally, impacts to any natural hazards, wetlands, floodplains, or steep slopes, scenic, historic, cultural, open space elements that might exist on the property. So this is a property that's basically flat. It's not within any overlay districts that we have adopted. And so principally we're looking at factors 1 through 4 and 7 when it comes to the positive balance of factors, and we believe that it does represent that. With respect to the zone change, those are set forth in Chapter 1768. They include requirement to be consistent with the goals and policies of the comprehensive plan. Public facilities and services must be presently capable or able to be made available prior to a certificate of occupancy for any new uses on the site. The service must be sufficient to support the range of uses and development allowed by the zoning. So this being proposed zone is R6 single family residential. The understanding is the applicant wishes to make lots for single family homes. And we believe that the analysis has been prepared, shows compliance with that factor, with that criterion. Separately, there is a finding with respect to the transportation system being adequate. John Rapplinger, our transportation consultant, has looked at this and determined that that standard is met. And finally, we've addressed the statewide planning goals that through our comprehensive plan, all of our statewide planning goals are addressed through our comprehensive plan. So to the extent that those are applicable, we've made findings of compliance with those. Chapter 3.09 Metro has a very similar set of criteria, but it also talks about the requirement to do joint planning within the urban growth boundary. And that means coordinating and providing notice to Clackamas County, which we've done. making reference to the Clackamas County Comprehensive Plan for this area, which we've done in the staff report, and making sure that the proposal is consistent with our current urban growth management agreement with Clackamas County, which it is, and also with the Metro Regional Plan, which is the urban growth functional plan that I mentioned earlier. And then we also make similar findings for whether the proposal is timely, orderly, and economic with respect to the provision of public facilities and services. So we've done that. Finally, wanted to address Senate Bill 1573, which is the requirement that if you meet the 4 criteria spelled out here, that the property can be annexed without requiring a vote of the people. So this property is within the urban growth boundary. It is subject to the comprehensive plan, and it has a comprehensive plan designation. It's contiguous to the city limit, and it conforms with all the applicable requirements for annexation. Oops, sorry. So our staff recommendation for this proposal is approval with conditions. The set of conditions that you see, the first 16, 17 conditions are all pertaining to the public works engineering requirements for the minor partition. The remaining ones have to do with planning's requirements for proportional mitigation on the transportation system, and the findings for consistency with Chapter 14, our annexation criteria, and which service districts are going to change as a result of the annexation. So I'm happy to answer any questions you have. Our recommendation to the Planning Commission is to forward a recommendation for approval to the City Commission for this application. Thank you.
Are there questions of staff? Let's see. Our favorite one, number 22.
I'm sorry?
Our favorite condition, number 22, has to do with tree mitigation.
Okay.
I did see on the minor partition plat that there are a number of fruit trees and some large trees. The larger trees don't look like they're like on the edge of the property lines or the potential property lines, so may or may not have to be removed.
One moment, let me get caught up with you.
Get there. Yeah, and I sent you that email, so when you'll have to see my staff report. So when I printed it out, items 2 through 19 say error resource reference source not found.
Okay, thank you.
So that's okay. I got
Yeah, we reposted the agenda because what happened was basically the engineering staff had tried to add a link that linked the condition of approval to the relevant criteria in the website. And it, for some reason, that link did not work when we published the agenda. So we just went back and changed it all to text.
Yeah. Oh, that Public Works people.
An attempt to be helpful. It was a good idea.
I said that's an interesting condition.
And it might work in the future. So we're going to correct that.
Yes.
Sorry.
I thought that might. That's okay. I got it later on, but it was just odd reading it.
Yeah. Okay, so
condition 22. Attention.
Thank you. Yeah, I had the other staff report up. It's a pretty standard condition for us to finalize a tree removal and mitigation option plan prior to recordation of a final plat. If the reason being we added this condition is to acknowledge that the applicant is proposing to preserve certain trees. And to accommodate that proposal, bearing in mind that things do change in the field, and we do have clear and objective standards with respect to mitigation if it turns out the trees have to be removed during whatever stage between now and final plat recordation. And then we want to make sure that the relevant code criteria for protection of existing trees is added to all the applicable construction plans, and that any alternative proposal for mitigation conform to Chapter 1741, but not have to require that they come back before the Planning Commission if that is the situation. So that's why that was written that way. However, the applicant has proposal to keep trees number 109, 110, and 111. Tree 106 as well. So, anyway, that's, those are the proposals, yeah.
So I also wanted to ask about, since we talked about access, so parcel, sorry, I'm off the minor partition now, so parcel number.
2 is the one with the house on it.
Get back to
Right,
the
so parcel
partition
number
plan.
1 would be the newly created parcel number 1.
Yeah.
So would they be taking their access off the easement to the rear, or would they be granted access onto Maple Lane?
That's
Again,
my understanding.
I
is
have
that that's
questions
what they
about
got. Yeah.
with Maple Lane, until they step up some enforcement there, it's, like I said, it's like a little freeway.
Yeah, we will be restricting access for any new parcels there.
But yet we are requiring that the house be oriented so that its frontage, the
Thank you,
architecturally
yeah.
significant portion faces.
Yeah, we have a requirement that when you have a street that's classified as a collector or level higher, not a local street, but higher, that parcels orient their front lot line and their most significant elevation for a new house toward that street for a number of reasons, because we want to limit 6-foot fences along there.
Right.
Provides a more safer environment for pedestrians and provides eyes on the street. And you can see how that's worked as some of the subdivisions have
Right,
gone
yeah,
in.
I noticed that.
Yeah.
I think that in order to minimize its impact from Maple Lane, that house could be set quite a ways back on that property. I mean, it doesn't have to be
Yeah.
right on the street where it would possibly cause some noise or some other sort of mitigation type concerns.
Yeah.
Okay.
Yeah, we do have a requirement like that for through lots.
Yeah.
But yeah, parcel 1 is not a through lot, so, we would look at that when an actual house is proposed on parcel 1.
So that could be oriented so that the garage is in the back and they come off clear.
Yeah, frequently, I don't know what housing floor plan would work on that parcel at this time, but, they could propose a number of configurations that would comply with the requirement and also with the residential design standards.
So what are we saying about parcel 1, that access to?
So the front of the house would orient this way.
Well, if they're closing this one, he has to close this one.
Onto, any new house would be oriented the front of the house towards Maple Lane. There would be no driveway access or garage in that situation.
So how do they gain access to Maple Lane?
From over here on the existing street to via an access easement across parcel 2 and parcel 3.
I don't know how they get from here. They don't get that.
That's a proposed easement. Yeah.
That's how they get the access. That's what I saw.
So it functions somewhat like a flag lot.
All right.
But it's not a flag lot.
But it's not a flag lot.
It has an access easement.
So I think you have a couple of slips for us that were set over there.
Oh, thank you. Can see that.
Great. We'll trade you. Thank you. All right, why don't you both come on up at the same time? And just for remembering parts, just give us your name and for the record. Okay. And either one of you can start.
I'll start.
Okay.
Okay. Hi, I'm Debbie Cleek. I'm with the Booking Group. I'm a planning consultant. Did you need my address? No. No, okay.
Got it right there.
And I am representing Dean.
Dean Cunningham, the owner of the property and submittal applicant. Yeah, whatever.
Applicant. And we really don't have a lot to add to the staff report. We appreciate staff recommending approval and working with us on the on our proposal. Just to cover some of the questions you asked. You were asking about Tract A in the
subdivision to the west. And that's, I don't know if it's an alley or a private street, but either way, it's privately owned by the subdivision next door, so we don't have any access rights to it or any ability to use it
Sorry,
to
I'll just, that's the
access.
aerial photo over
Yeah.
there.
Yeah, well, the city limit thing is right on top of it. So.
Right, it would be real handy if we did, because then parcel one could kind of be a flag lot coming off of that, but because we are not proposing any access to Tract A. And the county, I think it's mentioned, will not permit us any access onto Maple Lane to control traffic. And so we're not doing any access of any of the parcels onto Maple Lane. The existing driveway for parcel 2 will be closed off when the street improvements are done, and parcel 1, as it was noted, will be getting their utilities and access through that access easement that's sort of split between parcel 2 and parcel 3. So again, it'll sort of function like a flag lot, but we'll actually have frontage onto Maple Lane, but no access. The side setback to the existing house between parcel 2 and parcel 1 is a 5-foot setback, meeting the R6 requirements. And I think that was everything, other than, just thanks to staff for the tree mitigation condition of approval, giving us flexibility. We don't anticipate needing it, but all of the trees that are being preserved are surrounding the existing house. So there shouldn't be any issue with keeping them, because there's not a lot of construction proposed for parcel 2, but we just appreciate that flexibility in case a tree dies or something unanticipated happens. But other than that, we're real happy
the
with
ones that would be on proposed parcel 1.
Those are fruit.
The one. No, I'm not talking about the fruit trees. I'm talking about, looks like 12 something or other red leaf maple and a blue spruce. I know that we addressed the tree approval criteria. There was quite a few trees on the site that aren't healthy or weren't good specimens. And so we are proposing to keep the trees that are the highest quality ones on the site. And tell me which ones are those again? I'm looking at it.
Yeah, I didn't bring the arborist report. Possibly staff might have a copy of our arborist report.
It's bundled in with the application materials here, so. See if I can pull that up. Okay, starting on page 23 of the 126-page application packet. Well, I just want to say that because it's 23 of 126.
23. Okay, I'm on 20. Oh, okay. I have 23 of 57.
So you've got tree number 101, which is not shown on this plan, but on the
I only have 57.
is a blue spruce.
I only have 57 pages. Is this on, it's on another attachment?
It's on the application, on the agenda, if you click on applications.
Their application.
Your application?
I'm not on their application, I'm on your report.
So I'll just continue reading that.
Okay, keep reading, I'll see if I can find it.
Tree number 101 is a blue spruce with 2 codominant stems. Structural defect of the tree, weak attachment, high failure risk. Tree 108 is a blue spruce, similar condition, 2 codominant stems, weakly attached, vertical crack and bark inclusion. Structural defect is a hazard, high risk of failure. Tree 112 is a birch. It appears to be in decay. Several dead branches caused by an insect called brown birch borer. Pest is killing birch trees throughout the metro area. So I think that those 3 are rated poor and are proposed for removal. And our policy, our code is that if it's determined to be dead, diseased, dying, or hazardous, it is removed from the mitigation calculation entirely. And what the mitigation is based on is healthy trees on site and where they fall in relation to a building footprint. So the calculation of mitigation trees is based on what's remaining after those dead, diseased, and dying trees.
Page 24 has a detailed inventory of the species of trees and conditions there, and then the tree inventory and tree mitigation approach is based off of all of that. Page 26 has X's on the trees that are proposed to be removed and in relation to the parcels. So that is, that would be useful to have up on the screen right now, but I don't have it. So
I've got it.
Yeah.
So it's 107 going down here. It was in good condition. The red leaf maple.
It's outside of foot.
107 and 25-inch maple in the setback area. Let's see.
Yeah, it was listed as good in the.
I don't think you should take that one out then.
Good incremental growth, nice shade tree.
Then they'd have less mitigation.
Well, I will just say that, yeah, we can't force an applicant to preserve a tree if it's in this situation. In every case, we do base the mitigation. The mitigation is higher for trees that could be preserved or that fall in a non-construction area. If there's an easement or other utility situation in the way that requires that the tree be removed, then they may need to be removed for that reason, but perhaps the applicant should shed light on that.
But again, I hate to beat the dead horse, but you can't mitigate for a 25-inch maple. I just, if there's any way that it can be saved, it should be saved. I just, every site does not have to be scraped. I understand about the fruit trees, because I get that. But it said it was in good condition, and there's a way that a house could be built without that having to be taken out.
So I would note that we did meet all of the tree preservation requirements as they're written. So we met the approval criteria.
I understand
that tree, as we explained, the utilities and access to parcel 1 are all going to be coming from the rear of the site. So if you look at that lot, most of the development on that lot is going to be towards the rear of the lot. Sort of the garage will be rear loaded. It's a 22-foot tree, and so actually the root protection zone infringes quite a great deal into a 58-foot wide lot, so half the lot would be inside of the root protection zone.
A good faith effort to try to keep it.
Dean, do you want to speak to that
If
at
we
all?
could have access from Maple Lane, we wouldn't have to have
We have
that.
no control over the
So I
county.
don't-
We don't have any control
Yeah.
over the county, believe me, we've
Yeah.
tried. You don't want to have access from Maple. I'm just
we can try our
I'm
hardest.
just making a request,
Yeah.
not a requirement. I'm just saying, do whatever you can do to try to
If it's
save
at all
it.
possible, yeah.
Yes, because a big tree is way better than a little tiny tree.
Do you have something to say?
No.
Anything else, gentlemen?
I just have a quick comment.
Okay.
So basically you're dividing this up because you're tired of mowing all this?
Yeah, pretty much, yeah, exactly.
This is a zone change.
Don't humor them.
Well, I mean, I can see.
I'm tired of having a horse on the property is why.
Yeah, see all these little houses and you're busy mowing and taking care of it.
It takes 4 hours.
And they're busy flipping burgers and enjoying life.
Yeah,
You're like,
exactly.
No, but the horse has to have some place to go.
That's what the apple tree's for.
Got a couple of questions.
Yep.
We spent a lot of time on that minor partition here. Any comments in support of the annexation and the zone change?
From us?
Yeah.
Oh, well, I mean, it's certainly, the parcel is surrounded on all sides by the city of Oregon City and the R6 zoning. And so it's matching the fabric of the area. It's supported, there's existing sewer and water in Clearwater Place already to be able to serve the lots. As well as we mentioned that the Clearwater is entirely improved with a sidewalk on the west side of the street. So I think
We'd just be improving Maple Lane
Yeah,
Seemed like we'd be doing
we
the
did meet with
stadium.
the Clawfield Neighborhood Association, who were highly in support of it, and I think they put a letter in our application addressing their support because they were pretty excited to see the sidewalk be continued along Maple Lane, and they thought that was going to be a nice thing for their neighborhood to have that sidewalk continue. So it's really just, we want to match what's in the area and give the owner an opportunity to add some additional lots and get rid of his horse.
Let's make a motion.
Get rid of the horse.
Make a motion?
No, we have not closed the public hearing.
Okay.
So we cannot do that just yet. So any other further questions? Okay, thank you. Any further questions of staff? Okay, then I will close the public hearing.
Did you want to ask for any public comments?
There weren't any others.
Just.
Everybody's for the
Everybody's for the next one. Because I said, I don't have any slips, and I said, and then they go, so I checked on that. All right, gentlemen, would you like to make a motion?
I made the last one, so.
Oh, gosh, well, maybe it's Bob's turn.
No, I'll defer to my good friend there in the green shirt, or red. Oh, red, I'm sorry, total blind.
Sure, I'll do it. Move approval of annexation zone change, GLUA 1820, AN 18.2, and ZC 18.1, and MP 18.4. Minor partition of 0.76 acres.
Is there a second?
I'll second.
All right, seconded by Commissioner Johnson. Call for the vote.
Commissioner Gah?
I wish you would have started at the other end,
I'm trying.
or alphabetical. It's a minor annexation, but you know, to be honest, I'm still a Senate Bill 1573 conscientious objector. Until it's settled a little bit in the courts, I'm not going to vote for this annexation. I'm a no.
Commissioner Maybe?
Aye.
Commissioner Espy?
Aye.
Commissioner Mahoney?
Aye.
Commissioner Johnson?
Aye.
Chairman Griff?
And I will vote aye with, again, the please try to save the maple tree. It's not a requirement again, but I'm just asking. Aye.
Motion carries 5-1.
All right. And we are going to take a very short recess. We will be back at 6 minutes after 9. Thank you very much, Dean. And Debbie, say hi to Bev for me.
For me, this is like the perfect reason why the voter annexation is coming up.
Okay.
Because elevator magnet with the picture on it?
No, I don't have an elevator magnet.
I do.
I have an elevator magnet.
Okay. Yep.
I bought one of those.
All right.
I actually haven't gotten it yet, but I have to go get it.
Yeah, I'm excited about it.
Okay. They kept telling me, oh, they're coming, they're coming. And of course, when they came by, I didn't have any money.
We have 50 minutes.
All right. Or less. So.
To my doorstep.
Everybody turn their mics back on. All right, thank you. So we are back in session. And our last item, public hearing item for tonight is, what the hell does GLU stand for?
General land use application.
Jeez, that's so we have application GLU 1825, VR 1801, lots of zeros and one, SP 18106, and modification 1801, so a modification of conditional use permit 1401. And if it's okay with you, I do not want to read that again. You're good with that? Okay, thank you. But we will ask the commission if they have any ex parte contacts, or did they visit the site, or anything else that precludes you from making a decision tonight. So we'll start with Bob.
I visited the site, no ex parte contact.
No ex parte contacts. I walk by on a regular basis as I live in that neighborhood.
I drive by it on a regular basis. I was president of the South End Neighborhood Association where they did the presentation. Did not ask any questions. I just viewed the presentation.
Drive by the project on South End Road many times and have not visited it, stopped to look it over in any detail, and no ex parte.
No, my covered wagon doesn't go out that far.
And I guess I should mention that I was part of the planning commission when the original project was proposed and approved.
I believe we all were.
Yep. Not everybody, Vern wasn't.
Excuse me, everybody was except Vern. Yes, I did visit the site. I do not drive by the site on a regular basis, so I did go to the site. I did get out of my car. I did walk the site, and I did not see anybody or talk to anybody, so I do not have any ex parte contact. Does anybody wish to challenge or question the commissioners about what we did or didn't do, or what I saw and what I did not see while I was there? Nope, okay, all right. Are you up again?
Yes.
Oh, awesome.
All right, so this application involves a minor site plan and design review, modification to the conditional use CU 1401, and an administrative or minor variance from the lot coverage requirements for a 7-bed expansion to a 31-bed assisted living memory care facility at the northwest corner of Amanda Court and South End Road. So the proposal is to enlarge the existing building by approximately 529 square feet in order to facilitate the 7 additional beds, and that is a slightly more than 40% of the lot coverage on a parcel size of approximately 39,439 square feet. The building footprint is approximately 15,323 square feet. The other part of the proposal is to add an ADA accessible ramp at the rear of the property, restripe the existing ADA accessible parking space at the front of the property, add a 7-foot tall wrought iron fence surrounding the outdoor cafe area. And right now there are 9 on-site parking spaces, 8 in the rear and the 1 ADA space in the front. Approximately 38% of the site is landscaped, which is above the 20% minimum required. Traffic analysis indicates that the impact associated with this expansion of beds by 7 is fairly insignificant. It would add 1 additional morning peak hour trip for a total of 5 morning peak hour trips, and 1 additional evening peak hour trip for a total of 8, and a total of 101 peak weekday vehicle trips. The existing use is an approved conditional use in the R10 single family zone. And this is the code citation for that. Any licenses or permits required to operate the facility as a assisted living facility or nursing home is issued by the Department of Human Services separately. This is the aerial photograph, 2017. You can see that all of the site improvements that were required as part of the original conditional use application and site plan have been installed, and that includes sidewalks, both along Amanda Court, which is a local street, and South End Road, which is a minor arterial road. There's street trees. You can see in this.
Before you leave that.
Yeah, sure.
What the heck is the brown area on the upper left-hand corner? Because that's where I went in the back and I thought, well, that's not landscaping.
This here? This.
Yes.
Yeah, that is a storm drainage infiltration area that takes roof drain and puts it into that facility.
Does it look just like
yeah.
I didn't see a drain, but I saw basically it's like a bunch of gravel.
Yeah, it's basically a bunch of gravel. I'm not sure what the underlying part of it is.
Or anything like that.
It was signed off by Public Works as an approved on-site storm facility with a maintenance agreement that the Public Works Department can access the
storm
site.
chamber under there.
Yeah. The utility has an overflow in the event that it overflows and can connect to city storm. But our requirement is that they try to infiltrate as much on-site as possible. Yeah. So that's what that is. And it was approved by Public Works.
How quickly I forgot.
We never saw the actual engineering. We
And you
saw
can
the
see,
location.
No, we didn't.
see the parking lot to the rear. You've also got on-street parking along Amanda Court, but that's not necessary to meet the on-site parking requirements. And then you've got the driveway that comes in via South End Road and Amanda Court. This is the ADA parking spot. There was a porte cochere here, or cochere, I can't say that.
Porte cochere.
Thank you. And that's the principal point of vehicle access for pickup and drop off. We anticipate that staff and visitors would use the parking lot in the rear or park on the street. This is the Google Street View from September 2017, indicating the current improvements out there. You can see this fairly extensive landscaping.
Looks pretty minimal.
Zoning, entire area is R10, single-family residential. You can see the area in the star there. This is the proposed south elevation change. So this is facing Amanda Court, and you can see what the proposal is as far as expanding out that particular section of the building to accommodate a bedroom and reuse the window there. And then the section facing Amanda Court where the wrought iron fence is for the outdoor cafe and a step would be put in down to the sidewalk.
Pete, when you say a bedroom, are you talking about to accommodate 7 beds or just one bed? Or?
1 bed on that side and then 6 on the north side.
Okay.
Yeah, I think that's correct.
Unfortunately, that was, I have to say, it was really hard from these plans being so flat and done by a computer. It was really hard to tell where the addition was actually gonna happen.
Okay, well, hopefully I will clarify that with the floor plans that they've got in there. Sorry, this is the north elevation proposal and an
Okay, so
enlargement.
we're in the little tiny letters that says building addition.
Yeah, so you've got 4 bump outs right now that would be extended out towards the north or interior property line, 10 feet from the interior side yard, which is the minimum setback for the R10 zone.
And how many
Currently
feet
it's
is there now?
15 feet,
There's
more or less.
15 feet there
Yeah,
now.
yeah. And then also on that side that's not shown, there's a section of lawn and landscaping and a 6-foot privacy fence. This shows where the ADA ramp platform would be constructed on the rear. And
You're doing all that, and of course, we don't,
Sorry.
we don't get to see that.
to the rear of the property, you can see the section of the ADA ramp that would be put in where there's a current porch.
Not sure what's the front and what's the rear.
This is the rear proposal. You can see the ADA ramp proposed.
That is a heck of a long ADA ramp.
What are they gonna do with that other door?
Hang on, we'll find out.
And I'll let the applicant address that question.
Okay.
East elevation here is, we're going to discuss this in more detail, but there's a condition of approval with respect to transparency. When the original proposal was approved, the finding for this facade was that they had 53% transparency, even though it was less than 60%, and we approved a modification for that. Turns out, and the architect is going to talk about this, they don't have 53% transparency. They're currently around 48%, so they're proposing to add a window in over here, which will get us closer to...
You want to do that again, Pete?
Sorry, over here on this side, where there's currently a window, but to keep the window over here. Anyway, we're going to talk about the percentages and what that's going to look like in terms of rhythm. So it's a residential structure, the way it looks, but it's actually built to a commercial standard. We applied the transparency requirements for a commercial building to a structure that is somewhat residential in nature. Here's the site plan. Hopefully this will shed some light on where the actual changes are. So on the northwest side of the structure there, you can see some hash marks, and that shows the building addition there, and the changes to the square footage. On the southeast side over here, you can see the addition on that one small corner. And then where I showed the ADA ramp on the rear is going in this location. And then we also have the ADA parking spaces as well. Right now, the concrete sidewalk that is the public sidewalk on the South End Road side and the Armanda Court side, that provides the pedestrian access between the on-site pathway to the rear of the building and to the front door. So there's currently no on-site paths on the south elevation or the north side. So when we require on-site pedestrian access, if it's proposed, it's not necessarily required as long as there's a public sidewalk that does the same thing. In this case, it does. But if somebody wants to put in an on-site pathway in addition to that, the pathways have to be at least 5 feet wide and hard surfaced. So we had a condition of approval to address that. This is a very detailed floor plan. I'm not going to go into detail on this, but it indicates the areas which are proposed to change on the interior of the site with the clouding there. That's in the packet. Our staff report addresses the following criteria here. I'm not going to list these, but some of these have been already met and therefore are not applicable. Public and street trees, for example, already installed. Stormwater management has been addressed. There's no significant grading, filling, or excavation proposed with this. All the street improvements have been installed, and there's no changes proposed to the number of or the layout of the off-street parking spaces. There would be some very minor erosion and sediment control requirements with the building permit. And then the 7-foot wrought iron fence is subject to 17.54/100. Normally in a residential zone, the height limit is 6 foot for a perimeter privacy fence, and it's, I'm not sure that you would call the fence around the cafe area a privacy fence per se, because it's internal to the site. However, it's a 7-foot fence, and under the code, you can propose a 7-foot fence through the land use process. So it's in keeping with the architecture of the structure.
How is that?
Well, you've got some wrought iron fences that are shorter, 5 foot high along the southern perimeter of the site. And it's a very short section of fence that's about 20 feet off the property line. And it's just on that southeast corner of the building. Realistically, it's necessary for security of the residents who'll be using that patio area. And that's why they proposed a 7-foot tall fence.
Because they might climb out?
Probably several other reasons as well. But so we reviewed the conditional use criteria again, because this is modifying that original proposal and the additional beds associated with that conditional use, and found that those criteria are met. I want to go into detail on the minor variance. So with the footprint being increased slightly, it does bump the lot coverage over 40% by 0.19%, or 88 square feet. A very small amount. They've justified their minor variance, and I'm paraphrasing here, based on these factors. The addition to the south side of the building would not negatively affect any structures that are across the street. And the addition to the north side of the structure is within the required interior side yard setback, 10 feet for the site. The stated need or hardship, depending on how you want to phrase that, is that the memory care patients spend the majority of their time indoors and in their rooms, and given the need to add those units and the existing design of the building, the applicant believes that that's the least amount of coverage, lot coverage required to facilitate the additional space for those additional residents.
I will have a question about that.
Okay.
Not for you.
Okay.
For them.
40% lot coverage is a typical residential lot coverage. As I mentioned earlier, this is somewhat of a hybrid, commercial residential use. So if we were to review it against a typical commercial use, we'd allow a lot higher lot coverage.
I apologize, I don't understand that. This is a residential zone. It is a building for residential occupancy. We didn't tell them they had to build it to a commercial standard. So the residential standard applies. I don't see how that makes any difference. I don't understand that.
Well,
it's not, if it was a commercial zone, it was a commercial building, I could understand that, but it is not.
We reviewed it against commercial institutional design standards.
But it's a residential institutional building.
Fair,
Isn't this registered or licensed by the state?
Yeah.
Don't they have standards for?
Well, they wouldn't
It
have
doesn't
standards
apply
for
to
lot
variance.
coverage.
This is a variance request.
Yeah. So this is just a local criterion for lot coverage.
Okay.
Very small additional lot coverage, basically, if you want to go with the residential lot coverage standard, which is what we've reviewed. Mitigation for the minor variance, they've discussed that the addition basically extends the existing bump outs, which are articulated on the back of the building, and that the section of the building there is only 1 story tall. It's not 2 stories. So it's not going to have the same effect that a 2-story building would if you had expanded a 2-story building 10 feet from the property line. And there is existing landscaping and privacy fence there as well. And that we've made findings that all of the comprehensive plan goals and policies relevant to this type of application are supported. We did include 5 recommended conditions of approval. They deal with the width of the on-site pathways, requiring those to either be 5 feet, 5 feet, yeah, wide in accordance with that code requirement, or be removed from the site plan. Chain link fence that's currently on the site would need to be removed. It's only at the rear of the property, and I believe it's providing some sort of temporary security. And that would have to be removed and replaced if they're going to keep it with an appropriate material. The transparency requirement we'll need to address as we discuss this. The outdoor lighting requirement. So what happened with the outdoor lighting, we issued the building permit, and what was installed afterwards did not meet our lighting plan that was originally submitted to you and approved. So we're requiring that the applicant prepare an updated lighting and photometric plan that conforms to the lighting standards. So there's some existing wall-mounted lighting that we don't know what the lighting levels are. And we have to check that. There were several things about the installation of various things on that building that were done after the fact without staff's awareness. So, yeah. I can't answer that with any real clarity. And the new owner is, proposing to remedy that. Screening for mechanical equipment, we have a requirement that if you have mechanical equipment, meaning HVAC equipment, air conditioning, that sort of thing, and it's ground mounted, or wall mounted or roof mounted, that it be screened from view to a certain percentage. In this situation, we have some ground mounted air conditioning units adjacent to each of the rooms that we need to confirm are adequately screened. So we've added that condition as well. It can be done via an actual structural screening wall or via landscaping as well, through the use of landscaping.
We have some testimony about that particular.
Yes, thank you. We did receive testimony on that, and it cited the exact code section that we are required to comply with. They asked Mr. Gregory Peterson, I believe, wrote comments that we required that the applicant address this, and we've done so through this condition of approval. That can be done via a type 1 minor site plan after the Planning Commission approves, if you're comfortable allowing the Community Development Director to follow through on that condition of approval. Now, I want to briefly talk about some of the testimony that we would put before you tonight. It has to do with a dispute about the ownership of the property. And so what we're dealing with in this situation is there has been testimony that the former contractor has made some claims as to ownership of the site and provided testimony in that regard. As Carrie alluded to earlier with the earlier application, we base our criteria on the land use criteria, and in this situation, we were using the assumption that the current listed property owner under the Clackamas Assessor's records was correct, and that the applicant that signed the land use application is aware of the situation. Is
there a dispute?
There is a dispute about it. So we'll need to talk about that in more detail with help from the city attorney.
So the question is who's on first then?
Yeah.
So just quickly, we can resolve this pretty quickly. So Jeffrey Wellington signed the application, and we didn't know who Jeffrey Wellington was, and we received an email from a representative of Empire Building claiming a lien right through a foreclosure over ownership of part of the property, and that's what's discussed in this email chain that you have on your dais.
Yeah, that was
And so we forwarded that material on to Mr. Wellington, and Mr. Wellington has provided a copy of a deed that was recorded on November 21st, indicating that the property is owned by River Terrace Memory Care Property LLC. And I will distribute to you, and for the record, the Oregon Secretary of State Corporations Division Business Registry that indicates that Jeffrey Wellington is the manager of River Terrace Memory Care, which would resolve the issue because he is the representative for the property owner. So as far as I'm concerned, this is evidence of that the owner of the property has filed the application and satisfies that requirement from the city's perspective.
Okay.
So what you're saying is just because a lien is put against the property doesn't restrict it from being subject of a land use application?
No, but lawyers will tell you different, I'm sure.
We review the evidence that we have, right? I mean, and we determine who the record owner is based on the evidence we have. I don't have any reason to believe that as of today, River Terrace Memory Care property is not the record owner of this property. If Empire Builders was to come to this hearing and bring some other evidence, then we could evaluate it. But as of right now, this is the evidence that we have before us, and that's how I would base a determination on who the record owner is.
Okay, well, the application says it's PBREFL, whatever that is, 1 LLC from Seattle.
Right, and then we've also got the statutory warranty deed.
Right, okay.
That transfers that grants to River Terrace Memory Care from that entity.
Okay.
So the only thing I would add is this is coming before you because the original site plan had a condition that any change to the site plan that was proposed back September 22nd of 2015 would need to be reviewed by the Planning Commission. And so that's why this is coming before you as a modification.
Okay.
Thank you.
Any questions of staff? All right. I have a number of people who have signed up to testify. Jeffrey Wellington.
I'm just passing through.
As long as you're not passing out.
Hi there, I'm Jeffrey Wellington, owner, manager of River Terrace Property LLC. I have with me our architects, John Lape, as well as Brandon Lanius, and then our attorney as well, Victor. So we'll start with, I would propose we'd start with the architects to present some things.
Okay. I've got John and Brandon.
Hi, my name is John Lape. I'm the architect for this project and my business in Portland, and we specialize in memory and assisted living communities.
And I am Brandon Lanius. I work with John.
And he's the project manager on this project. We've worked with Pete and staff for several months on this. Been good to work with, and most of the information is in their staff report. Most of you, I assume, are fairly familiar with what's happened with that project. It was built in 2016 and operated for a short period of time. This is a new team, completely new parties that are working on it, owner, management, architect. Our work has been to make some improvements to it. There were a number of accessibility issues that we felt needed to be addressed, one of which is that rear ramp. others inside the building, location of toilets and some technical aspects like that. Lighting improvements were required by licensing. And then to try to increase the capacity of the building to serve more residents of Oregon City that need memory care assistance. Those were minimum standards. We met with licensing. The size of the units, licensing does have a minimum standard that technically the units in the rear met, but there are additional requirements other than the technical aspects that need to be provided. Some security and individual spaces within a double room. And that's why we felt we needed to push those rooms out, so that we added the bump outs in the north side are 5 foot long. Plan is to continue to operate it as a memory care facility and to open it next spring. I want to address a few things that came up during the staff report. One was the other rear door. We determined in looking at the building that there's two rear doors on the west side to the parking lot. They both have steps. Neither one of them are accessible. They also don't meet code because there's a step right outside the door. So we felt that we needed to add a secondary accessible entrance exit to the building that would meet the code requirements, which one in the front would not do. So the front door and this new ramp would meet the accessibility requirements. The second door that we took out, which is shown, the new window to replace the existing door, that exit is not needed from a number of code requirements, so we took that out, especially because it would be in the way of the ramp. We want to leave the parking lot as it was.
You're talking about building code requirements, right?
Yes, correct,
okay.
yes.
Because code
Well,
could be zoning code, could be some other codes. I just want to clarify for anybody that's listening and for us, because I wasn't sure which code we were talking about.
Very, very good point, because that's the next code. There was a comment about the height of the fence around the cafe area. The management team wanted to provide so the interior courtyard of the building, which nobody can see from the streets, is a very nice, secure area for the residents, and that's where they can come and go as they please. Management wanted to provide a secondary area out there that would allow the residents to sort of see beyond just four walls of a courtyard. So they wanted to fence that area in that's right now called a cafe area. Licensing has a requirement of a 7-foot high fence for just what you mentioned, climbability. So that's why that fence is proposed to be 7 foot. The other issue that came up was lighting, and I'll kind of talk about that, I guess. Staff mentioned 5 conditions of approval. We're fine with condition 1, the sidewalk widths, the chain link fence. Yes, there's an existing chain link fence on the north and the west side. The funny thing about the one on the north is there's actually 2 chain link fences. We have one, and there's another one a couple inches away that the neighbors have in there. They're both chain link fence. They're both site obscuring to some extent, but we understand that the chain link is not acceptable. So the plan is to replace the north of the building, that area, which will also help minimize the expansions that we're doing. And the screening of the mechanical equipment, condition 5 is not a problem. We will add landscaping to meet that requirement. I mentioned outdoor lighting. What was added, there were 14 fixtures totally that were added. 4 were motion detection lights, and I'm not sure why they were added. This is just what the people did. I'm trying to interpret what was done. But 4 were motion detection lights for security. And those are technically exempted from your site requirements. 2 bug-eye fixtures for egress, and those are required by building code. Lighting. There are 4 small wall sconces. There's 2 larger wall sconces in the front, and then there's 2
hanging pendant fixtures underneath the entrance. It's a total of 14. Don't have any problem with providing an updated site plan, lighting plan that will show those. Wouldn't mind not having to provide a photometric plan for that, but if need be, we can do that. The transparency thing is the one I really would like to talk about. And if you could put up that one page, 14 of your report.
Right, let me switch over here. Is it page 14 of the staff report you want to look at?
Yes, correct.
Okay.
We don't have any problem with the Amanda Court elevation and percentage of windows and all other things. It's this elevation that faces South End Road that we'd like to talk about. The requirement of commercial.
This
Yes.
is, okay.
That is the elevation we're talking about. And that's as modified. So requirements are 60%, as Pete mentioned. Conditional use in 2014, you approved 53%. But when we do the math on it, it was only about 48%. Both what actually was approved, which was in the staff report of CU14, and built. How it got there, I don't know. Certainly some things were changed, we know, in this building as it was done, but that was actually back in the staff report. So we have a challenge with that. We're keeping all the windows on the facade. Originally, we were in the bump out. As I look at that on the left side, on the south side, is we're changing a public room to a unit. And so we were kind of minimizing the windows in that room, not to overwhelm them. But in discussion with Pete, that was part of the original facade. So we've added that window back in. It's not shown there, but it will be as we move forward.
Where's that going to go again, Pete?
So that would be
Oh, there, okay.
over here.
Right.
It would be behind where the fence is.
Yes,
Okay.
correct. And so we're going to add that back in. There was another issue with a window that's shown there that they actually moved to a different location, and so we're going to replace a solid door there with a door with a light in it, so get that transparency back. But
Where's that, John?
and that's just to the right of the one. Yep, right there. That's actually was built as a door, not a window.
Okay.
And so we're going to leave it as a door, but we're going to change it to a door with a full light in it.
So can you get to 53?
I can't. Well, okay, let me get there. So.
It's only 5.
Well.
The number 5.
I agree. Here's what the math does. So right now, since our building is 4 feet longer, we have 45.9% transparency. What I look at this building, yes, I don't live here. Some of you drive by it all the time. It's a nice looking building. It's a shame that it has been vacant for a while, but it's a nice looking building. And the forward part of that has nice symmetry around it. It matches what's going on inside the building. It works well. To get to 53%, we would have to add 7 foot 3 inches worth of glazing along that front facade. Can it be done? Yes. Does it help it? I don't think so. I think it would damage what's there. As an architect, I feel it really has good symmetry, good character. And quite honestly, as you push that transparency higher towards 53, if you want, or 60 even, you're getting, it's a commercial criteria imposed on a residential building, and this is a residential neighborhood. I don't feel that would help, so I'd like to see that condition removed, frankly. That's all I have. I'm here to answer any questions you might have.
Oh, go ahead.
I just am curious about on the extension to the north side.
Yes.
That just seems like a natural location for another window, which would increase your transparency.
About right here?
On the north side, which, you meaning the interior or over here?
Right there, yep.
Oh, okay, sorry.
Yeah, it would. It's 100 feet back from the street. It's way back there. It's a room where we have double occupancy in that room. The reason we've added that, I don't remember exactly how that room lays out, but they're kind of a Jack and Jill bed scenario in those rooms. And there may well be a bed right against that wall.
I'm not sure what you mean by Jack and Jill.
Well, it's a.
I know who they are, but I don't know how it applies to everyone here.
It's well, in a bathroom situation, that's what it is, yes. But this is where we created a sort of S-shaped room in working with licensing on this. So there's a bed here. If it's a rectangle like the drawing, there's a bed against this wall and a bed against this wall. And there's an element between to give them some sense of privacy with still access to the window.
And you said that the building is currently vacant, so there isn't anybody occupying it at this point?
That's correct. Okay. That's correct, yeah.
Question on your addition of 7 extra beds, or 7 additional beds.
Correct.
Why 7 and why the addition?
Well, mostly it's a matter of economics, cost of purchasing, building, and operating. I mean, I've been in this business for longer than I care to admit. There are a whole bunch of buildings around this state in particular, because we had a true advocate for memory care in particular. I mean, Oregon really did sort of start to develop the memory care business, frankly. But there was a model there of about 30 beds, and most operators that I work with, and I work with people from all over the country, frankly, that's hard to make that pencil. This was 31. It's marginal to make it pencil, and when you have an occupancy of 85, 90%, you know, losing a bed or two is pretty critical. Part of the new owner's due diligence on this was to do a market study, and there's a market strong enough to support 37 residents, and those are pretty small geographic areas that looked at. So that's to meet the needs of the Oregon City residents.
But that sounds like a personal problem. That's an economic hardship is not a grounds for variance. So you kind of just sank your boat right there.
Well, I'm...
Because you've got commercial on one side, you're saying, well, we're not commercial, but then over here you want to be commercial, so you can't have it both ways. It's either residential or it's residential. It's not commercial, so...
Well, we're trying to meet those needs for the residents in the best way we can.
The future residents.
Yes.
Because there aren't any there.
That's correct.
Yeah, so I'm looking at your variance, and I don't support those lightly, because there really needs to be, all the criteria has to be met, and you have just not met one of them, because you're saying that in here, that it's the minimum to allow the residents. Well, I don't know about that. Adding more beds is something you want to do because it's a financial thing. That is not a criteria for a variance. Financial need is not a criteria in my mind. So, well, and even though it's small, I mean, I don't want to argue with it. I'm just saying that is what I'm seeing and that's what I'm reading. And I'm listening to your testimony very intently, and I'm having a hard time with it. Because again, minor variance, major variance, there's no real difference to me. It's a variance. So you're asking for an exception, and you have to show why you need that exception.
Can you make this facility work without the 7 beds?
Well, I can make it work without the 88 feet to put us over the variance, but it's really tight. I mean, to do that, because we have, I mean, our whole addition is 529 square feet.
So those rooms are single occupancy right now? I mean, would be single occupancy.
Correct. And so I could meet technicality, I can meet the regs with an addition that doesn't ask for a variance. I'm not sure the math, but the room extensions would be something in the neighborhood of 1'4" shorter than they are right now. We're extending them 5 feet. We would extend them 1'4" or so less. We chose not to do that because it really makes the rooms awfully tight. And that's the reason. If we were not granted the variance, we would cut that back and still have 37 beds. We would just have those would be a little bit tighter.
Yeah, just to be honest with you, sir, it's not you. It's so the next person comes in and asks for a variance and says, oh, ours is only this tiny, so we need a variance. And then the next person comes in and says, oh, well, ours is only this tiny and we need a variance. So then,
I understand.
I'm not looking at just this. I'm looking at sort of a bigger worldview. And again, I'm not saying I can't be convinced, but I got to go by what the criteria says, and I have to go by what was written. And that's where I'm having a little bit of the heartburn.
It seems like the variance is self-imposed through design and economics. And our standards for reviewing variances is due to a characteristic of the shape of the lot that is not through any fault of the property owner. And boy, I'll tell you that you saddle us with a real challenge when you mention economics.
I understand.
That's throughout the state.
I understand that.
Perhaps balancing the one-story design with two-story and the need to add the beds on the one-story could help. I don't know.
We can't go to the second floor.
Oh, that's what I mean. Is that the constraints that are associated with having to build on one floor might end
Well, also realize that the market study showed a demand in Oregon City area higher than the 37 beds, higher than the 31, obviously, but higher than the 37. So it's a balance of trying to help meet that demand.
And that's as opposed to all the other ones that are in the Oregon City area as well?
That includes that, yes. That includes also things that.
There are lots of them, and one supposedly coming, one that's going to be built, I understand.
Yeah, it includes the ones that are proposed.
Yeah, I guess
those market studies.
So there's a restriction against building two stories there, is that?
No, there's no reason.
No, it's a building code issue.
Okay. Because I mean, pragmatically, I'd rather see the one-story design that fits with the neighborhood character rather than.
And when we're going around with our walkers, we're going to need one story.
Right, and so I'd rather see a variance get approved and preserve the one-story design as opposed to putting, not needing a variance and going up two stories, I guess, is what I'm trying to say.
Well, and again, the issue is we will still do 37 beds. We just won't do them quite as well.
Yeah, I'm just trying to brainstorm with you on some physical characteristics that might be constraining for you to justify the variance.
And 95% of this is on the north side where it's really not impacting the street view. And we're moving the air conditioning units to the side and some other elements back there.
So is there the ability to screen so there's a variety of ways to screen. And I am assuming that the person that made this comment is probably looking for something that would be screened immediately, not, if you're going to use plants, then they can't be really tiny little plants because that's not going to screen anything. And even though they will eventually grow up, that's going to, they're supposed to be screened. And waiting 2 to 5 years for something to be screened is, to me, not really acceptable. And I don't think with the comment either that's acceptable. So there may be some other options for screening besides using landscaping, unless it's mature landscaping.
It can be, as Pete mentioned, if you, part of the discussion with this certainly will go on the record that we have plants of certain size that will do that screening when planted.
When planted as opposed to when mature.
Right, yeah.
Okay.
Exactly.
Well, I think the heart of the conversation is whether or not the variance is self-imposed.
Well, that's usually what it is. That's generally what happens.
Self-imposed because of economics.
Yeah.
No offense, but.
So anyway, well, all right. Any other questions for these guys?
Well, we didn't get the, just to be clear on the transparency issue, with the two changes you're proposing, along with the additional square footage or surface area, I guess, for lack of, you're going to drop from 48 to 45 feet, percent.
Yeah, 45.9, yeah.
Yeah, okay. Okay. So that puts you even below the original design drawings and below the original approved variance.
We didn't do a variance.
Well, modification, whatever it was,
a modification.
Yeah. Okay, I just want to be clear where.
Yeah, which for reasons I have no idea why. I mean, we've looked back at what was submitted, we've looked at what was built, and we just can't do the math to get to what.
Just to be clear though, what was built was what was submitted in the drawing.
Yes.
So the original calculation of 53% was just in error. It was 48%.
As to the best, and we have.
That's fine. I just want to make sure that it wasn't one of those that, oh, and then they decided to not put in 3 windows or whatever, and it changed.
That's correct. Okay. No, it was not.
Right.
So I just want to add one quick thing real quick, which is regarding the transparency. So we know now, based off your testimony tonight, that our proposed condition of approval to meet the transparency requirements to give those numbers doesn't work because your number doesn't meet our standard. We don't have a variance submitted for the transparency. The other option is to do modifications that better meet the design requirements. It's a subsection of our code, but we don't have any findings for that. So we may want to consider a continuance.
That's exactly what I was thinking.
My only thought, listening to all this, I've been really quiet about it, is
Are there any more questions for them?
it's about the economic part of it. I mean,
Do you have any more questions for them?
I guess it's not specifically.
Okay,
for
so we're good.
Thank you.
You just have a comment for us.
Thanks very much.
Go ahead.
He mentioned economics, and several of you hit on that, and I kept thinking, but he still would go ahead with the 7 rooms. They would just be smaller, and I think of the seniors that I visited in those homes, and I hate to see them cramped even further than what they currently are. So my thought is, if he's still going to go ahead with that 7, are we willing to overlook the economics for the comfort of the seniors that are going to have to be there? Is it going to make that big a difference? I don't know. I'm just
I don't either.
throwing it out there.
I don't see that in the criteria.
I hate to see seniors
That's not how-
cramped
yeah.
into
It's not-
small
it's not
places
how
all
it
the
works.
time. I know it isn't, but to him, he mentioned economics, and we all hit on that. Well, some of you did, but he's still going to do those rooms no matter what, even if he has to make them smaller.
So are we
I
relying
just
on?
want to point out on page 16 of the staff report, the issue of economics is not one of the stated reasons for the hardship. It may be more broader than you would prefer. However, it is written such that what they're stating is that it would allow the facility to give more space to the memory care patients who spend a majority of their time inside the facility in their rooms, and given the need to add the units and the design of the building, they believe that's the least amount of lot coverage required to provide a comfortable space.
And that translates into.
Well, I'm just saying that that's not necessarily an economic argument.
Right.
Well,
I agree with Pete on that.
I agree with what you said, but I'm also listening to the testimony, and that's.
Yeah, I just wanted to point
that's
that out
exactly how I read
in the
it.
finding, so if we're going to modify that.
But I mean, all these developments have to pencil, and I think he was just repeating a well-known fact that these things really have to.
I agree, but
really have
that's
to
what I
work.
saw when I read that.
But I don't want to put too much weight in this. I'm assuming we're relying on 1760-30 variance grounds for this review, correct?
Correct.
Okay, so we have the variance may be granted only in the event the following conditions exist, that like to cause substantial damage to adjacent properties, minimum variance that would alleviate the hardship, would not exceed the purpose of the regulation to be modified.
I'm trying to find what the hardship is. That's.
But I don't see hardship in these criteria.
Didn't you just read that?
I said, well, yeah, but it's a minimum variance.
Right, that would alleviate the hardship. And again, I'm not sure what the hardship is. The hardship is something that's not caused by them. It's caused by some, as Bob aptly stated and quoted, man, your memory is just good, man. But anyway, so I don't want to debate it right this minute.
I think it's based on the existing building design that they have and their inability to do anything other than what they're proposing.
You don't have to know.
Well, I know, but
again, we have two more people who have slipped, so we can talk about this. But I think according to what staff said, we're probably looking at a continuance. So, Victor, did you have anything? I'm sorry, I can't read your handwriting, and I'm loath to try to pronounce your last name.
And also, excuse me 1 second, I just wanted to chime in to note that the time is past 10 o'clock.
Let's keep going.
We have two more people.
Yeah, so I just want to acknowledge that the process is, if we have a unanimous vote of the Planning Commission, we can go until 11.
We won't be going till 11.
But we need to take the vote.
Well, since he's here, let's hear his testimony and then we can vote.
Victor Rame, Sussman Shank. I'm the attorney for the applicant. I'll reserve any comments to the extent necessary during the rebuttal period to talk specifically about the ownership issue if that comes up. But otherwise, I just allow time for others so that we can move on.
All right, so gentlemen, may we have a quick vote, please, so that we can finish the testimony?
Do we have to stay till 11, or can we see it?
No, we're not staying till 11.
Does this have to be recorded, the vote?
Yes.
No, it's just a head nod.
Yeah, so
it's not an official vote.
We have one more person that wants to
Let's
testify.
do one more person. It's going to be continued anyway.
Yeah. So is that okay with everybody? Okay.
Yeah, we're good.
All right, Inga, come on up.
I'm Ingra Rickenbach, and I am a close friend of the person who sold the property and didn't get paid for it, where they built that home. And so I am concerned about certain things. When it was open, I took a tour to see what it was like, and I know I was concerned about those back porches because that's where they were going to put anyone in a wheelchair, and then they're going to have to take two people to bring them down. So I'm glad to see that there's a ramp there. But when they originally were going to develop that, they were supposed to mitigate the tree when they took down the huge sequoia. And so they just planted trees right next to each other along the back property line. I guess that's the north side, and I'm not sure if those trees made it or not. But also, they were supposed to take care of their own water drainage so that it didn't go to the city and into the other things. Well, the way they built it, they put something in there, but it's above the ground. It's higher than the blacktop. So there's no way it can drain into that. And the guy was showing me, he said, yeah, that all goes out to the street and then the city takes care of that. So I am just concerned.
Is this on the south end side or is on the Amanda's side?
It's in the very back, in the parking lot.
Oh, the gravel pit. Okay.
But they had like a drain back there. You said you hadn't seen one, but when I came out the back door, I said, that's too high. And he said, oh, no, because, if it would flood and the streets flooded, then we could take care of water. But it wasn't something that they were worried about. And so I'm just concerned. I know that the rooms in the back were made small enough so that Medicaid patients could be there. And the other ones, I think, were full pay. And so they wanted to make sure they could get some government assistance. But, and I know there's new owners now, and I hope that it gets run better than it was before. And I have really hard feelings against Empire Construction. I went down to when they were doing went down to the courthouse stairs, and the people who had partnered with the Empire builders had someone there to offer money, but they didn't have enough money. And so it went back to the people who they'd borrowed the money from. And there's just a real sour taste in my heart for my 93-year-old friend who doesn't have money to live on. And I know that you can't do anything about it, but I watched that property for her. She is now living with her son because she can't afford to live in Oregon City. She lived with me when before she got sick, so that she could watch and see what was going on. And we followed it from the ground up. In fact, we were on the ground when Petronella came over and warned us that we shouldn't be trespassing because it could damage. Somebody could fall in that. But anyway, I just am here to make sure that the best thing happens. And on the picture up there where it showed the part going out to Amanda Court, is that going to go beyond the wrought iron fence that's there now?
Let me find it. Here?
No, the front elevation. Well,
front elevation.
When you showed the front elevation, okay, and see where is that the 7-foot fence?
No.
That's in the front, or that's the fence that's there now?
That's proposed.
Well, that's the proposed, because is that addition going to go all the way out to the wrought iron fence that's there?
He's saying no, behind me, behind you. He's saying
Oh,
no,
he's
it's not
saying
going to
no.
go out there.
Okay, because I'm concerned if it approaches the sidewalk and if
It's out towards Amanda, but not forward.
I know, but see that one that's going out towards Amanda?
Sorry, let me find the site plan. So this is where the addition is.
Oh, okay. I was thinking it was over with some of the other ones.
And this is the location of the proposed fence.
So that's going to be and the other part is the fence that's around it right now. Okay, that's all I have.
Okay, thank you. Any questions? Okay.
I just.
For her?
No.
Okay, thank you so much.
You're welcome.
Do you have questions for staff?
Yeah, and I mean, I'm concerned about the information on the stormwater, so.
They have some, so he can answer that, and then they have the ability for some quick rebuttal.
Yep.
On the stormwater, I want to check back with Public Works and see what the findings were, and also what the final stormwater analysis said based on the inspections that they did. Yeah.
If she says it's too high, then.
If you're going to continue it, you might want to reserve the rebuttal.
Yeah. Would you like to reserve the rebuttal?
No.
You'd like to rebuttal now? Okay, come on up. Thank you again.
Again, John Lape, the architect. On the storm drainage, I'm pulled out the Alta survey, which is an existing condition survey that's done after the building's there as part of the purchase. There is a catch basin back in that, what we've talked about as a gravel area in the northwest corner. That gravel catch basin rim elevation, which is intake, is 462.08. The back side of that parking lot is 462.5. So it's lower than the back of the parking lot. It's frankly higher than the driveway to Amanda Court. However, the drawing also shows a top of drainage area and the contours around that. So from that catch basin, should the catch basin fill, at least as designed, it then flows to the west and then down to the street. So overflows is headed that way as surveyed. So that's what we know about the storm drainage. I think the other thing that on the variance is what it is. We can either, again, we will do it at 7 beds. Whether we do it with an additional 88 square feet or not is up to you. I think it does help the residents give a better room out of that. Otherwise, we wouldn't be asking for that. But we will go ahead with 7, one way or the other. The condition 3, which is the transparency issue, correct me if I'm wrong, but if we remove that condition of approval, then that issue goes away and we can accept the building as designed and built.
Laura, I don't know how we can make that go away.
We would need findings to show that you comply with our code, or you have a variance, or you have a modification that better meets the design standards. So it sounds like you're, if it is continued, we can work with you on some of those, or point you in the direction for where those findings are.
Okay. Thank you.
Yeah, because that's.
We can't wave that wand.
Yeah, that's just too far off on the transparency requirements. So if you can get back up to the design, 48 to 53, it's at least then you're working with the original building design, which was erroneously measured, but at least you're replacing what was lost as opposed to losing more, which is a problem because you're already below the level. You understand what I'm saying?
Yeah, I do. Yeah.
So you're saying try to get closer to 48?
Yeah, get back to at least the original number, I think is a very minimal requirement. Because we approved the building with those dimensions. So I think that's, we have to live with that approval and work within that. So I think that's your goal number versus 60 or whatever the original 53.
All right, thank you.
I got a question.
For them?
Yeah, yes. Welcome to the state of Oregon. Process, process, process.
Oh, I know.
Okay, and LUBA. Appeals, pretty much because of process. And when you tell us that you can proceed with without the variance, but proceed with the addition of the 7 units. This commission approved that use with a specific number of units to begin with.
True, that's right. Yeah.
So in terms of the integrity of the process, Carrie, would that not require a reapplication of a condition, of an expansion of a conditional use? If they're going to add 7 more units? Without a variance, they'll just knock out a few walls, but they'll add some impact to that site with another 7 units.
Well, the modification file that is a modification of the conditional use, and it addresses the 7 beds additionally. So we made recommended findings that address conditional use criteria as well as the minor variance in addition to that in the staff report.
But the application comes for us for a variance, right? Or a variance plus.
Well, you've got 3 concurrent applications. You've got a variance, the site plan, and a modification. And the modification is for the conditional use.
Is for the additional 7 units?
For the 7 units.
Oh, okay.
Yeah.
But do we have to make a motion when we finally get to that point, addressing all 3 of the applications?
Yep.
Yes.
The variance plus the...
Yeah, all 3 at the same time.
Well,
I mean,
Okay, all right.
or you're, assuming you're going to resolve them all the same way. If you're not, you'd have separate
Then we'd
motions
have
for the
separate
various
All right.
applications.
That's correct.
That's what I mean by process,
Yes, which
process.
we have done before. We've split it out based on certain information.
Okay.
Okay. So you actually didn't have a question for them then? Other than
Well,
talk about the process?
The
Okay.
question that I get.
Okay.
No offense, but get my drift.
Yeah.
That's the
Okay.
question. He said, yeah.
Anything else, John?
No, thank you.
Okay, well, I'm going to go ahead and close the public hearing.
I just wanted to.
Yeah, go ahead.
Jeffrey Wellington. I totally understand what you guys are saying, respect what you're saying. I worked as a social worker for 14 years. I managed nursing facilities for almost 4 years. And I know that, the space of rooms is critical, not just for residents family members who are visiting, and I also know for staff members. So I know that that's a critical thing.
Okay.
Okay,
Thank you.
thank you.
Thanks.
All right.
You want to close it again?
Now, close it for real and allow for planning commission deliberation, and it sounds like we are going to need to have a continuance.
Yeah, I support that.
I think we've gotten everything out that we needed to.
Yep.
So why, I just want to be clear for the record,
Right.
why are we continuing? I mean, we have a little bit of, we went the input on the stormwater.
Yeah.
Right.
What else?
The applicant will either have to respond to the requirement for a modification from the transparency
Okay.
and provide additional findings in that regard, and we would need to respond to what they propose in that section of code.
Okay, so there's just
Yeah.
really those
Those
two
two
things.
things, right.
Okay,
Yeah.
I just want to be clear, so everybody doesn't waste a lot of time
Right.
Well,
working on things.
and to the extent the applicant might want to revisit this variance
Right.
discussion a little bit.
Sure.
That's true, yeah. And
Okay.
discussion of the hardship.
Yeah. Do we want to
Okay, yeah.
continue it to the 10th as well?
Sorry?
Pardon me?
Do we want to continue this to the 10th as well?
Yeah.
So,
are you going to still keep your world record and not make another motion?
I'm working on it.
Because, you can make them, you've done a few in the time you've been here. I know I've done one.
You've already been sullied, you might as well just do it,
Oh, gosh.
I know. We'll back you
We'll have to go
up.
through all those file numbers?
No, just move
I
and
move that we continue the
application.
the application.
Okay, right, okay.
until December 10th.
Right, so it's been moved and seconded that we continue, I just lost my.
JLUA
Yes, just read them.
1825, R 1801, SP 18106, MD 1801 of CU 1401.
Okay, seconded by Tom. All those, let's just do it. All those in favor?
Aye.
Aye. Okay, we're all good.
Let's stop and talk now.
All right. Do you have any quick communications for us? We noticed all the candidates left, but that's all right. We can.
You have one.
We have one. We can get them on at the beginning of the agenda for the next meeting. You wanted to introduce them, as I understand. That's what you indicated to me.
Good afternoon, or good evening. So I have a few different updates for you. The first is Planning Commission. The mayor will be appointing 4 members to the Planning Commission in the first meeting in January. We will be introducing them to you, but we're going to have a continuation of our normal Legal 101, which we normally do every January. We're going to start it in December this year at the next meeting. So on December 10th, you'll have the 2 continuances as well as this legal training.
You want us to come in a little early?
You can come in early if you like.
No, I mean, we'll be doing it earlier.
No, it's normal time. And so we will start the training, so it'll be a little bit more this year, and then it'll help support our four new people who are coming on board. Then.
Do you wear glasses? Well, you might need them.
Sunglasses when they turn the lights up.
So we welcome all our new planning commissioner appointees. But again, they're not appointed until the first meeting for the city commission in January, which is January 2nd. So until then, we're just learning together.
We're all 4 here tonight?
Yes.
Oh, I only saw 2. I didn't know.
Yes, they were. And then on other notes, alternate mobility targets was approved by the Oregon Transportation Commission, as you recall, for it narrowed down to only the intersection of Beaver Creek and 213. And rather than have a acceptable level of congestion for 0.99 V over C for the first 2 hours, we raised it from 0.99 to 1.00 for the first 3 hours. So now we regulate congestion for 3 hours instead of 2. But it's slightly higher than it was before. In mitigation for that, we allowed for a right turn lane from Beaver Creek Road going to 213 North. And then we have a couple other improvements that also support our bike and our pedestrian system as well. Our code amendments were already approved when you guys looked at the legislative file for that. And so that is all sorted out. The next thing is that we have our Beaver Creek Road Concept Plan implementation project that will start to be going underway very soon. We are about to contact property owners and let them know what's going on, and then we'll be reaching out for some public process on that. And we will likely be asking for some planning commissioners to attend those meetings as well.
So does that mean that we are going to actually designate those properties on the comprehensive plan?
Yes.
Those.
So it's taken 12 years, but we have a concept plan that is acknowledged, and it identifies generally what the uses will be within the area and a general map of kind of where things go and general street layout. What we need to do is apply that to zoning designations and make sure that we can implement the plan. And so that's the scope of this project, is to do the zoning comp plan amendments and any code amendments that we need to do to implement the required section of the plans, acknowledging that there are some aspirational things and some requirements as well. And then lastly, you all had identified wanting to come to the December 5th City Commission meeting for two reasons, really, for the code amendments and then also for the update to the City Commission. And so we'll be posting that agenda on Wednesday. We'll be attaching those policy advisement letters. Remember, we had the one, we split it into two, one related to the update, and then the other one related to the code amendments.
Yeah,
So
I have a clean copy of the first one.
do you want me to send out both of them to you guys?
Yeah.
Sure, I'll do that tomorrow. Other than that, that's all we have. We're taking care of the noticing requirements for the quorum for everyone to show up at Planning City Commission. That's all I have.
Yeah, I would appreciate if you guys would come.
Okay, yeah.
Be helpful if you can come.
Yeah, I've got arranged to get out.
What's going on with the Riverwalk?
We have an RFP out right now for someone to help us further the plans for phase one and then for the project. So we're moving forward. We're moving forward and it's very exciting. The RFP is still open. It hasn't closed yet. It got extended, but we are one step closer to having plans. Yeah, you will be seeing it come through the Planning Commission this year. As you recall, when we approved the Willamette Falls Legacy Project and the associated Riverwalk, there was a condition of approval that the Riverwalk design come back before the Planning Commission, and that the Planning Commission include two separate additional design professionals to help supplement the design on the Planning Commission. So we didn't know who will be on the Planning Commission back then. And so we'll be working through a process probably earlier part of 2019 to figure out how those design professionals will supplement it. We kind of went through this last year, so we sort of got delayed a year. But so last year we did this and we talked about having two design professionals provide input from over here, but not on the voting side of things because our municipal code doesn't allow that.
I know it won't be up here, but I'm obviously very interested in that because I was one of the ones advocating for that with Charles Kidwell, who thought that would be a really good idea.
Yeah. So we will
participating as a regular person.
Yeah, so we will be working through making sure that we are staffed up to support the Riverwalk project as it comes before the Planning Commission. And you'll probably see it, I don't know, summer-ish. Who knows?
So our meetings in December are basically the 10th?
It is. We are canceling the December 24th meeting because it's Christmas Eve. But actually, the city's open, so we can have it if you want to.
Bah humbug.
Well, I was planning to be here, but
I was going to open up presents.
I'm working on yours right now.
Are you?
Yes.
Thanks. Aisle 19 at Fred Meyer.
Yes.
Aisle 19 at Fred Meyer's, yes, exactly.
Great. Whack that gavel.
Okay, is there anything else, gentlemen? Okay. We are adjourned. Thank you, everyone. And thank you to everybody.